Distinguished delegates, please regain your seats. We are to start the 5th plenary meeting. We have a very long list of speakers, so we will try to start right now. I declare open the 5th plenary meeting. Today we will continue consideration of Agenda Item 9, General Debate. States are invited, in accordance with Rule 50 of the Rules of Procedure of the Assembly, to deliver statements of no longer than 5 minutes. In order to assist the speakers with the time delivery of their statements, a light mechanism is installed at the lectern. You will see, when you are approaching your 5 minutes, you will see a yellow light, and then it becomes red. Red means that you have exhausted your time. And we have really a long list, so I hope you can really observe this time limit. Pursuant to the Bureau decision this morning, the general debate will continue this afternoon and on Monday, 11 December at 11:30. So states also were able to submit written or pre-recorded statements in lieu of or in addition to their in-person statements by 4th December 2023 for posting on the respective webpage of the Assembly. I would invite delegations to please check the list of speakers dated 7th December 2023, 1:30. The list keeps changing, so make sure that you are looking at the one dated 7th December 2023, 1:30, 30:30, 13:30, available at the conference officer's desk, as indeed there has been multiple changes. Let us proceed immediately with our first speaker, His Excellency Mr. Kennedy Garston, Deputy Attorney General of the United Republic of Tanzania.
Madam President, Excellencies, distinguished delegates, at the outset, since this is the first time that my delegation takes the floor, I would like to join other delegations on commending you, Madam President, for the excellent manner in which you have steered the business of this session of the Assembly. I would also like to extend my sincere gratitude to the members of the Bureau, the Working Group, and the Secretariat of the Assembly for all the excellent work in preparing this session. Special thanks also go to Judge Hofmansky for his distinguished services over many years as the President of the Court. Likewise, I wish to congratulate the President-elect of the Assembly of the State Parties, Her Excellency Ambassador Pavin Kaukolanto of Finland, the two Vice Presidents, Ambassador Kanu of Sierra Leone and Ambassador Kasangana of the Republic of Poland, and the new Bureau. They can be assured of Tanzania's continued support and cooperation. My delegation also wishes to commend the retiring 6 judges for their excellent work and to congratulate the new 6 elected judges. We wish them all success in dispensation of their mandates. Madam President, 2023 is a significant year of the Court, especially as to mark the 25th anniversary of the adoption of the Rome Statute. Such a milestone certainly prompts a period of reflection and great actions. We therefore welcome the report of the Bureau on the plan of action for achieving universality and the full implementation of the Rome Statute. We wish also to acknowledge efforts done by the core focal points, the Republic of Korea and the Kingdom of the Netherlands, in promoting the universality and the full implementation of the Rome Statute. It is encouraging, therefore, to welcome Armenia as the new state party to the Rome Statute. Madam President, my delegation welcomes the efforts to ensure more balanced geographical representation and gender parity in the recruitment of the staff of the Court. We think ensuring equitable geographical distribution and gender balance would benefit the court with a diversity of perspective, increase creativity, and generate even more acceptability. These will ultimately enhance the universality of the Rome Statute. We wish to inform that the persistent recruitment of nationals of non-state parties to the detriment of unrepresented or underrepresented state parties does not only increase the perception challenges of the court, but also defies its legitimacy and may even ruin all good efforts underway by the court. Madam President, the United Republic of Tanzania welcomes the report of the review mechanism on the overall progress of its work for the year 2023. We note with appreciation that during this period of review mechanism concluded the assessment of all the recommendations which it had allocated to itself in the Comprehensive Action Plan. We call upon the implementation of many of the positively assessed recommendations which are not completed and in some cases have not even started. We also look forward to the preliminary discussion with the state parties and other stakeholders on the future of the review mechanism. Madam President, my delegation wishes to remind all state parties that the administration of international criminal justice cannot be fully attained without significant cooperation from all stakeholders. With this understanding, Tanzania wishes to commend the different cooperation efforts undertaken by the court with the support of state parties and other stakeholders in the year 2023. These cooperation efforts have enhanced cooperation and courts outreach. We wish to acknowledge and encourage the court and state parties to continue these important steps in making courts' work and activities more visible and bring justice closer to the victims. It is in this regard, Madam President, we would like to welcome with appreciation the continuation of the court's efforts in advancing discussions with the African Union Commission, aiming at developing a closer communication between the two organizations. Given the fact that, for the time being, the largest number of state parties to the court are in Africa, perhaps time has come for a court to consider having its physical presence in Africa. Similarly, we express great appreciation to the 19 state parties who have made a voluntary contribution to the Trust Fund for Victims in 2023. Madam President, we urge member states and other stakeholders also to make even more voluntary contribution to the Special Fund for Security to enable courts to implement the redesign the IT architecture and reinforce its physical security, especially after the event of the cyber attack that took place at the court. Madam President, let me conclude by reaffirming Tanzania's firm support to the court and our willingness to cooperate with the court and to encourage even more member states and non-member states also to join, but also do more in promoting international justice. I thank you for your attention.
I thank His Excellency for his statement, and now I invite His Excellency Mr. Michael Imran Kano, Permanent Representative of Sierra Leone to the United Nations.
Thank you, Madam President, for the floor. Madam President, Honorable Ministers, Excellencies, distinguished delegates. In the current turbulent times for our global community, with wanton perpetration of the gravest of crimes known to humanity, the relevance of the International Criminal Court within the Rome Statute system cannot be overstated. Sierra Leone therefore commends the court, its leadership, and staff, in spite of serious threats, for the dedication in carrying out its important mandate as an independent and impartial judicial institution committed to uphold and defend the principles and values enshrined in the Rome Statute. This 22nd session of the Assembly of State Parties has heralded leadership changes in the Assembly and a quarter of the judiciary of the court. The Republic of Sierra Leone congratulates Ambassador Pevi Kankoranta on her election as President of the Assembly, the Presidency and Bureau for the 23rd to 25th session of the Assembly. The elected Presidency and the Bureau will build on the excellent leadership and work of you, Madam President, and your Vice President and the Bureau. We thank you for your excellent leadership and contribution to the work of the Court and the Assembly and for the results achieved. Sierra Leone notes that the Court is in a consequential time, albeit a period with full optimism, given the seamless leadership transition in the Court, the ongoing work to strengthen the Court, and constructive resolution to address external threats. We congratulate the newly elected judges, applauding the structured process to ensure we elect highly qualified, geographical and linguistically diverse, and gender-balanced judiciary. We use this opportunity to thank the outgoing 6 judges, including the President of the Court, Judge Piotr Hofmansky, for their service to the Court and humanity. Madam President, Sierra Leone once again reiterates its unwavering support for the Court, with the attendant commitment to the victims. This commitment manifests in an active engagement in the work on strengthening the Court through the review process and call for universality of the Rome Statute, consistency, non-selectivity in the work of the Court, and for its adequate funding. We commend state parties, stakeholders, and the Court on the work done in the review process in the 3 years that have ensued since resolution ICC ASP22 Res 7 was adopted in 2019, formally starting the review process. The work has been comprehensive, substantive, constructive, and timely, addressing challenges and important matters relating to attacks on the Court, working culture, geographical and gender balance, the robustness of procedure and judicial determination, and these are examples of concrete ways in which the Court and the Assembly has responded to the 384 recommendations of the independent expert review. As we commend all involved in the review process on the substantial progress made, we urge for full engagement on the important question of the future of the review mechanism. Madam President, in agreeing with the stated view that universality is essential for the effectiveness and legitimacy of the Rome Statute system, we welcome the Republic of Armenia's ratification of the Rome Statute and look forward to Armenia's becoming the 124th state party and as part of the Eastern European Group. As we recognize the importance of universality, we are mindful that legitimacy is further built on the important principles of consistency and non-selectivity in the application of the Rome Statute. Victims of crimes within the jurisdiction of the Court deserve justice, irrespective of their geographical location, citizenship, or the faith they profess. Madam President, Sierra Leone's tenure as a elected member of the Security Council for the 2024-2025 term will commence in few weeks. With accountability as one of our priorities, and in acknowledging the key role of the UN Security Council within the Rome Statute system, we look forward to joining the other Rome Statute state parties to support the work of the Court, given the different yet complementary roles of the Court and the Security Council in addressing the gravest crimes of concern to the international community. In closing, Madam President, I'm pleased to announce that the Republic of Sierra Leone will formally submit to the Secretary General of the United Nations, pursuant to Article 121, Paragraph 1 of the Rome Statute, the proposal to amend Articles 7 and 8 of the statute. The purpose of the proposed amendment is to close the identifiable legal gap for slavery and slave trade crimes under the Rome Statute, as the statute does not contain provision for slave trade under Crimes Against Humanity in Article 7 and slavery and the slave trade as war crimes under Article 8. There is an identifiable legal gap, and this present legal omission in the Rome Statute results in significant impunity gap. We therefore call upon all state parties and all stakeholders to join us in closing this impunity gap by supporting the amendment of the Rome Statute. I thank you.
I thank you, Ambassador, for your statement. And now I give the floor to His Excellency Mr. Cornel Feruta, Permanent Representative of Romania to the United Nations.
Thank you very much, Madam President. Madam President, distinguished colleagues, in addition to the points made by the European Union, I would like to add a few points. I would like to express our appreciation, Madam President, for your activity during this Assembly of State Parties and in the past years. And Madam President, I think you've been doing a stellar work, and we are very grateful for your contribution in strengthening the court during these past 3 years. Romania was very pleased to serve as a member of the Bureau and as a focal point on non-cooperation under your able leadership. And we also extend our full cooperation to Ambassador Caucoranta and congratulate her on the appointment as the new ASP president, and Romania will be definitely supporting her work. Romania equally welcomes the election of the 6 new judges and is convinced that their work will contribute to the improvement of the efficiency and effectiveness of the court. We are indeed very grateful for the support of the state parties in electing Romania's first ICC judge, Iulia Motoc, and we are firmly convinced that the court will amply benefit from her vast and diverse experience. 25 years after the adoption of the Rome Statute, the International Criminal Court is an essential pillar of the international criminal justice system and has become a vital part of the international community's efforts to seek accountability for serious international crimes. Its investigations into an increased number of situations in all regions illustrate the growing need for accountability around the world. The activity of the ICC is crucial for the maintenance of international peace and security. We remain strongly committed to supporting the court's vital role in the fight against impunity and in providing reparations to victims of mass atrocities. The ICC relies on our collective support to carry out its mandate in an independent and impartial manner. We wish to stress the importance of cooperation of all states with the ICC, including with respect to the execution of arrest warrants. However, our support needs to extend beyond the fulfillment of legal obligations. We must defend the court consistently in the face of external threats and attacks. Romania firmly condemns the criminal proceedings initiated by the authorities of the Russian Federation against the prosecutor, the president, and other judges of the court. We stand firmly by the court's elected officials and its personnel. My delegation also strongly condemns the unprecedented cyber attack on the court and pleads for consolidating the resilience of the court in the face of such virulent actions. In any case, the court proves that it is a deterrent instrument, feared for its ability to sanction the gravest crimes wherever and whatever context these occur. We must protect it further, while not affecting its impartiality. At the same time, we must consolidate the ICC from within through a sober analysis of what needs to be improved and constructive engagement and political determination to find the right solutions. Madam President, distinguished colleagues, we warmly welcome the ratification of the Rome Statute by the Republic of Armenia. We continue to encourage all states to become parties to the Rome Statute and to the Agreement on Privileges and Immunities of the ICC. It remains our core belief that strengthening the ICC by achieving its universality is the most powerful preventive approach. As the court is facing a significant increase in its activity, we must equally provide the necessary financial and logistical resources for the effective functioning of the court. Romania has recently seconded a national expert to the office of the ICC prosecutor and is exploring ways to further supporting the activity of the court. My delegation would also like to thank the civil society organizations for their significant involvement and constant contribution in relation to the activity of the ICC. And I would like to conclude my intervention by reiterating Romania's unwavering commitment to the ICC and by underlining the need of strong, wider, and continuous support of states and international community for the court. Lastly, as his departure is approaching, we wish to acknowledge the crucial efforts of the Director of the Secretariat, Mr. Renan Vilasius, in the effective functioning of the Assembly and to wish him the very best in his future endeavors. Thank you, Madam President.
Thank you, Ambassador, for your statement. And now I give the floor to Mr. Andrew Murdoch, Legal Director of the Foreign, Commonwealth and Development Office of the United Kingdom of Great Britain and Northern Ireland.
Thank you. Madam President, Your Excellencies, distinguished delegates, I welcome this opportunity to address the Assembly on behalf of the United Kingdom. This anniversary year marks a significant milestone in the Court's history. The Rome Statute is a landmark treaty given life through the collective determination of the international community to address impunity and ensure accountability for the most egregious crimes. It is worth reflecting that 25 years ago, there were those who thought the court would be symbolic but ultimately a toothless body. Such pessimism has been proved clearly wrong. The court continues to grow and strengthen, including with Armenia's welcome ratification of the Rome Statute. Madam President, the United Kingdom would like to thank and express its deep gratitude to President Hofmanski, whose term as President of the Court expires next year. We also offer our sincere thanks to you, Madam President. As a judge, President of the Court, and as ASP President, you have been a loyal servant and champion of the ICC and its values, and we thank you for that. We also thank the outgoing ASP Vice Presidents, Ambassadors Sekwisenova and Ray for their exemplary service to the Court. Finally, we congratulate Mr. Osvaldo Zavala-Hilie on his election as ICC Registrar earlier the year, the incoming ASP President, Vice Presidents, and the newly elected judges. You can all count on the UK's support in the execution of your important mandates. Madam President, we commend the Court for its work this year, demonstrating its capability to successfully run 3 parallel trials, including the important conviction of Dominic Ongwen for crimes against humanity and war crimes. We commend the work of the Trust Fund for Victims, ensuring the interests of victims are central to the work of the Court. We also commend the Office of the Prosecutor for its careful prioritisation and use of resources, concluding the investigative phase of 4 situations since the last Assembly is part of an effective prosecutorial strategy to achieve better and more focused results. An agile approach to the Court's work is more important than ever, given the pressures it faces and on its limited resources. Madam President, it is perhaps a reflection of the Court's successes that we have been seen increased attempts to intimidate the Court and undermine its work. The criminal proceedings initiated by the Russian Federation against 6 ICC judges and the prosecutor and the cyber attacks were both cynical responses from those who fear the Court's ability to deliver accountability and justice. Now more than ever, the Court needs our support, and we stand in support of the principled stance of the prosecutor. Of course, such support need not be blinkered by the challenges the Court faces. While we welcome the progress made to improve its performance, effectiveness and efficiency, there is more that can be done. We congratulate the review mechanism and all stakeholders in the independent expert review process on completing the assessment this year of almost all of the 384 IER recommendations. Some of those recommendations have already been implemented, but the majority have not. It is vital that momentum is maintained to deliver the change that is needed. The UK firmly believes that states must help the Court to meet its existing mandate before asking it to do even more. Great caution needs to be exercised by states considering adding even more crimes to the Rome Statute, particularly where doing so risks divisions amongst states parties. And while we welcome the Court's 3 courtrooms being in full use this year, we remain concerned the lack of trials in the pipeline. But of course, the Court does not operate or exist in a vacuum. When considering what more the ICC should do to meet the expectations of states parties, we should also consider what we, the state parties, can do for the ICC. While state parties rightly seek the Court to do more effective and efficient, to avoid judicial and prosecutorial overreach and to respect complementarity, it must be equally be resourced properly. The United Kingdom supports an increase to the court's budget this year to ensure that it has the necessary resources to deliver what it is being asked to do. The court also needs states parties to cooperate on fugitive tracking and the execution of arrest warrants to ensure that, where necessary, individuals suspected of atrocity crimes are held accountable in The Hague. This will ensure the pipeline of future trials. Madam President, in closing, justice is a precursor to a lasting peace. The intricate relationship between peace and justice underscores the indispensable role of the ICC in the pursuit of a more just and harmonious world. The United Kingdom has been a steadfast supporter of the court since its establishment, and we continue to stand with the court in its global fight against impunity. Thank you.
Thank you for your statement. And now le doy la palabra.
I now give the floor to Her Excellency Marieta Carmen Squef, Permanent Representative of Argentina to the United Nations. Thank you very much, Madam President. The Republic of Argentina is pleased to once again be participating in this Assembly of States Parties and extends to you our most sincere thanks for your commitment to the task that you have led over the past year as President of this body. Your experience and aplomb have contributed enormously to strengthening dialogue between the court and the states during difficult times, and we wish you the very best in your future endeavours. We would also like to take this opportunity to congratulate the new President, Vice Presidents and newly appointed judges and the Committee of Budget and Finances, and we reiterate our predisposition and commitment to continue cooperating with them. We also welcome Armenia. Their ratification of the Rome Statute over the course of this year has allowed the number of states parties to reach 124. While this figure represents a significant number in terms of ratification, we must continue to redouble our efforts in order to achieve greater universality and to close the gaps of impunity. We reiterate our call to those states who have not yet done so to accede to the statute. At the same time, we note with gratification that following the activation of the jurisdiction over the Court over the crime of aggression, states parties continue to ratify the amendment. Madam President, this year commemorates the 25th anniversary of the adoption of the statute. This gives us an opportunity to take stock of the important work of the court since its origin and the challenges that it currently faces. Argentina was part of the original group of friends of the court and has been active since the beginning of the negotiation process, and we are delighted to see today that we have a court that is fully operational at the center of the international criminal justice system. The possibility of investigating and trying those responsible for the gravest crimes for the international community is fundamental in our fight against impunity. This represents a significant achievement, both in terms of attributing responsibility to individuals and also in terms of protection of human rights and accountability. At the same time, the court ensures that the voices of the victims are heard. Nevertheless, 25 years since the adoption of the statute, there are still challenges that make it difficult for the court to fully acquit itself of its mandate. In recent years, the court has had to deal with many challenges, some internal, some external. For this reason, states parties decided to begin a review process, which is reaching its final stages. This exercise has allowed the court system to carry out a full and comprehensive assessment of its operations, to identify and correct aspects that needed to be modified. Furthermore, the integrity of the court and its ability to fulfill its mandate are often threatened by external attempts to politicize matters or to exercise pressure in order to interfere with the independence of the court or the normal process of judicial proceedings. We reiterate that proceedings should be carried out in strict adherence to the legal criteria established in the Rome Statute. According to the principle of complementarity, it falls firstly to states to try and to prosecute the most serious crimes. This requires that appropriate measures provided for in the statute, including international cooperation, for them to be adopted at a national level. Given its nature as an international tribunal, the court cannot be sustained without the active and effective cooperation of states parties during the investigation and trial stages. In the same vein, we wish to mention that the adoption in May of this year of the Ljubljana and La Hague Convention on International Cooperation and Investigation Prosecution of the crime of genocide, crimes against humanity, war crimes, and other international crimes driven by Argentina, Belgium, Slovenia, Mongolia, the Netherlands, and Senegal. This new convention will substantially assist in strengthening the aforementioned principle of complementarity. Madam President, despite the difficulties, 25 years since the creation of the court, we do find cause for celebration. The court has prosecuted many allegations against perpetrators of grave international crimes, and this has led to many sentences. In these cases, the victims have been able to obtain justice and reparations. By way of conclusion, I wish to reiterate that Argentina will continue to be steadfastly committed with the court, and we will continue cooperating to help it fulfill its mandate fully. I thank you.
Muchas gracias.
Thank you very much.
Now I invite to take the floor Her Excellency Ms. Helga Kron-Karlsdottir, Legal Advisor of the Ministry for Foreign Affairs of Iceland.
Madam President, it's a privilege to address this assembly on behalf of Iceland. Allow me to express Iceland's sincere appreciation to the court and its officials in all organs. I would like to congratulate and welcome the 6 newly elected judges to the court. Iceland believes that the due diligence process is an important step. This year, we celebrated the 25th anniversary of the Rome Statute. Iceland expresses its continued support for and commitment to the ICC and emphasizes the need to improve and strengthen the court in all its functions. In the face of threats and attacks to the court, its staff and those who work with the court, support from states parties is more important than ever. Madam President, Iceland ratified the Kampala Amendments on the crime of aggression in 2016, and this year marks the 5th anniversary of the activation of the ICC jurisdiction over the crime of aggression. The jurisdiction is, however, limited to when both states concerned have ratified the amendments or when the Security Council refers a case to the court. It is undeniable that the international community is facing serious challenges at this moment in time, including Russia's full-scale invasion of Ukraine. These challenges have highlighted the fact we need to remove obstacles limiting the court's ability to deliver justice for the crime of aggression. Iceland acknowledges the vital role of the Security Council within the Rome Statute system and its ability to refer cases to the court when the ICC lacks jurisdiction. We regret that the Security Council has not made full use of its mandate to refer cases to the court when jurisdiction is lacking. Madam President, the ICC must be empowered to achieve its primary goal of providing justice for victims and survivors. Iceland highly values the role of the Trust Fund for Victims and by now contributes annually. We believe all efforts of the court should be built on victim-survivor-oriented approach, emphasizing the right and agency of individuals involved. Iceland welcomes the Office of the Prosecutor's commitment to systematically address sexual and gender-based crimes and in taking a more focused approach to investigating and prosecuting for crimes rooted in misogyny and queerphobia. Furthermore, we welcome the new policy of gender-based violence. Further, we would like to highlight the importance of civil society organizations to the court functioning. Human rights defenders and civil societies are often at the forefront of gathering evidence on violations of international law. It is unacceptable that these organizations face threats and harassment. Madam President, Iceland reaffirmed its unwavering support for the ICC as an independent and impartial judicial institution. Political and financial support for the court is essential. Iceland stresses the need for sustainable resources across situations and cases. Regular allegations from all states parties is essential as the court's workload continues to rise to unforeseen heights. We urge all states parties to pay the annual contribution on time. Iceland is now in the process of making a third voluntary additional unearmarked contribution in less than 2 years' time, the latest one to be made following calls for resources in light of developments in the Middle East. However, we want to stress that the court should not be dependent on voluntary contributions. The international community bears a shared responsibility to maintain justice and prevent impunity. Therefore, we strongly encourage all states to ratify the Rome Statute and join as states parties. To conclude, Iceland reiterates unwavering support and gratitude for the court, its elected officials and its personnel, and our commitment to defend the principles enshrined in the Rome Statute. I thank you.
I thank you for your statement. And now I invite His Excellency, Mr. Mahmoud Daifala Mahmoud, Permanent Representative of Jordan to the United Nations.
السيد الرئيس.
Madam President, I would like to seize this opportunity to praise your efforts in the presidency of this Assembly and the facilitation of its work over the past period. This period has been facing many challenges that you have addressed with wisdom. I would also like to extend my thanks to the Presidents of the ICC and the Prosecutor and the Registrar for their consistent efforts in order to achieve the noble purposes of the Rome Statute. We hope that these purposes would be achieved through more work. We would also like to extend our congratulations to the elected President of the ASP, Ambassador Paiva Kakuranta, as well as the elected judges. We wish them every success in their great mission and the massive workload ahead of them. Jordan emphasizes the importance of the active role of the ICC, which was established as an independent international judiciary institution to be the backbone of international justice in order to prosecute and punish international crimes and grave violations of international humanitarian law. Madam President, Jordan has been very keen to support the court in order to enhance its frameworks and structures. We have also been keen to participate in efforts aiming to review the system of the court in order to enable it to carry out its functions effectively and efficiently and implement the standards of justice, balanced geographic representation, gender balance, and representation of the principal legal systems of the world, in addition to the implementation of the standards of sound governance. After more than 20 years of the adoption of the Rome Statute, we will spare no effort to continue to abide by its principles and achieve its universality. Madam President, we support the mandate of the International Criminal Court in combating impunity, and we support it as an embodiment of the rule of law. And we emphasize the importance of the principles of impartiality, independence, and integrity as the basis of the Rome Statute system. People always turn their eyes to the court and wait for it to uphold its mandate in the face of the powers of injustice. We cannot establish peace and settle conflicts without providing justice for the victims and punishing the perpetrators and holding the states that have caused their suffering legally accountable. Madam President, the massacres Israel is carrying out against Palestinians in Gaza have reached a level of savagery and barbarism and disregard for human life and human dignity and a disregard for the simplest humanitarian values that is unprecedented in modern history. The number of Palestinian martyrs who have fallen because of the Israeli shelling of the Gaza Strip since the start of its aggression on the 7th of October of 2023 has reached more than 17,000 martyrs, 70% of whom are women and children. This is in addition to thousands who are still under the rubble. There is no family in Gaza that has not buried some sons and daughters. There is no family that is not still waiting for even the simplest hope that the Israeli killing machine would pause so that they can bury some of their loved ones. Their homes were destroyed on top of their heads. And those who have escaped are being chased by Israeli strikes in the north and in the south. The Israelis say to them, "There is nowhere for you to run. We will kill you wherever you are. We do not care about your lives. We do not care about calls for ceasefires. Nor do we care that the UN has described the Gaza Strip as hell on earth. And that is because we have power and support. Our soldiers commit the most atrocious crimes. And they even documented themselves on social media every day. They take pride in these crimes. But we do not care, because we know that the international community will not call for us to be held accountable. We have suffered the Holocaust, and therefore we are entitled to do what no one else is entitled to do." This is the logic that Israel is dealing with you with. Madam President, the life of Palestinian children is no less important than the lives of Israeli children. The life of the Palestinian woman is just as valuable as the life of any other woman in the world. For each of these people, there is a life story that came to an end because of the crimes of Israel. And unfortunately, these people have become, in the eyes of some countries and social media outlets, mere numbers. They try to justify this to themselves and to their peoples as unfortunate casualties of war that must be accepted in order to satisfy Israel and quench its thirst for murder and vengeance and destruction against the unarmed Palestinian people. In other areas of conflict, the murder of civilians is described as a crime of war. It is condemned and deplored in the strongest of terms, and different legal and political mechanisms are mobilized to put an end to it and to punish its perpetrators. The UN Charter is constantly paid lip service to in the General Assembly in order to show displeasure that its provisions are being violated. But when Israel begins carpet bombing Gaza, these same people turn a blind eye. When Gaza's hospitals and mosques and churches are bombed, along with UN facilities that are sheltering more than half its people, when more than 80% of the residences of Gaza are destroyed, when its people are displaced from the north to the south and then bombed in the south, and then told to go to the Egyptian borders, what does the international community say? They say all parties should respect international humanitarian law, and we have deep concern towards what's happening to civilians in Gaza. We call for respecting the inviolability of UN buildings. When Israel withholds water and fuel and food and medicine and the simplest humanitarian needs from the sector, what do these people say? They say, we urge the entry of humanitarian assistance, but also it is important to release Israeli hostages. Deliberately or unintentionally, these people link providing assistance to the people of Gaza to the release of the hostages. Tens of thousands of Palestinian hostages being held by Israel under the worst possible humanitarian conditions are not even mentioned. Israel is harming and torturing them, and they are not mentioned, as if they and their lives have no value. Madam President, this silence and complacency towards The crimes of Israel and its barbaric actions emboldens Israel to move forward in its genocide and ethnic cleansing of the Palestinian people in Gaza and in all the occupied Palestinian territory. And so long as the international community will not call things by their names in terms of the massacres, death, and destruction that Israel is bringing upon Gaza, it will continue in its aggression and its grave violations of international humanitarian law. Esteemed delegates, ladies and gentlemen, you are now standing before a critical juncture of human history. And if the international community does not uphold its historic responsibility towards what is happening to the Palestinian people in Gaza, genocide, murder, and displacement, this will be a mark and a precedent in terms of how the international community deals with similar crimes in the future. If you would like to empower the International Criminal Court as an effective mechanism of the international community in terms of enforcing international humanitarian law and combating impunity, then you must call for accountability for Israel for the crimes it is perpetuating against the people of Palestine in Gaza. The prosecutor must immediately investigate these crimes and issue warrants as needed and begin in trials. The prosecutor has the authority and the court has the jurisdiction to do so. And failing to take responsibility towards what's happening in Gaza will have terrible impacts on the viability of the court in the future. As for its success in standing on the side of right and justice and the rule of law, this will actually support its independence and its mandate, and it will achieve our mutual goal of enforcing international humanitarian and criminal law and preventing immunity for international criminals. That is your choice as countries and as the court. Thank you.
I thank you for your intervention. And now I give the floor to Her Excellency Ms. Margaret Bambui Nuji Shaba, Ambassador of Kenya to the Kingdom of the Netherlands.
Thank you, Madam President. Excellencies, heads of delegation, esteemed delegates, distinguished ladies and gentlemen. The Kenyan delegation is honored to participate in the 22nd Assembly of States Parties to the Rome Statute of the International Criminal Court. This year holds particular significance as we commemorate 25 years since the adoption of the Rome Statute. The Republic of Kenya lauds the leadership of the outgoing President, Her Excellency Sylvia Fernandez de Gomendi, the 7th President of the Assembly. We similarly acknowledge the leadership of the two outgoing Vice Presidents, Ambassador Katerina Sekwensova of the Czech Republic and Ambassador Robert Keith Ray of Canada. And we congratulate the two incoming Vice Presidents, Ambassador Michael Imran Kanu of Sierra Leone and Ambassador Margareta Kasangana of Poland. We thank the Secretariat and all who have worked tirelessly to ensure that the Assembly continues to fulfill its role of providing management oversight regarding the administration of the Court. We also express our gratitude to all states parties for bestowing upon our nation the honor to once again serve in the Bureau. Madam President, 2.5 decades ago, on the 17th of July 1998, after a 6-week marathon, 120 countries adopted the Rome Statute to the ICC, marking a watershed moment in the international criminal justice system. This collective effort represented a monumental step towards eradicating tyranny and impunity, showcasing the immense potential of human endeavor when united for a just cause. For Kenya, this quarter century is not merely the passage of time. It signifies an enduring commitment to the rule of law as a situation country for over half of this period. We welcome the winding up of investigations that spanned over a decade on the Kenya situation. More significantly, our nation's perspective is that the international criminal justice system has evolved, demonstrating the increasingly crucial role it plays in realizing lasting peace and justice. During this time, the necessity of a robust international criminal justice system became evident, highlighting the cardinal principle of international law, that is, complementarity. Indeed, a strong international criminal justice system must be complemented by robust domestic and regional mechanisms to ensure its effectiveness. It is therefore the challenge of our time for all states parties, the court, and stakeholders to fortify their collaboration in strengthening the national and regional institutions to enable them to deal with international crimes. Madam President, Excellencies, the 25th anniversary of any human endeavor is a pivotal juncture, prompting one to reflect on the journey traveled thus far. Therefore, as we mark 25 years of the Rome Statute, it is a time for introspection and a moment to consider the challenges and opportunities that lie ahead, both those within our foreseeable future and those that remain unseen. As we mark the seasons gone, the echoes of the timeless statement by Dr. Martin Luther King Jr. on the arc of the moral universe come alive. Through his profound teaching, we affirm that the arc of the moral universe may be long, but eventually bends towards justice. Therefore, as we look into the future, we acknowledge the collective responsibility we share in shaping a future where impunity has no refuge anywhere in the world. It is against this backdrop that Kenya expresses gratitude to His Excellency Ambassador Michael Imran Kanu of Sierra Leone and His Excellency Paul van den Eyssel of the Netherlands, together with the ad hoc country focal points for their stewardship of the review mechanism since 2021. Due to their efforts alongside the country focal points, the Assembly has been able to categorize and develop a comprehensive action plan for the assessment of the international expert review recommendations. While the mandate of the review mechanism, largely achieved, the focus will gradually shift to monitoring of the implementation of the IER recommendations. Our view is that the Bureau of the ASP should continue with the monitoring function, assisted by the already existing facilitations in both The Hague and New York. Kenya will continue to support necessary reforms to the court that are done through a considered and nuanced approach, so that the Assembly may decisively tackle the remaining structural and operational challenges facing the court. Madam President, Excellencies, Kenya congratulates the 6 newly elected judges of the International Criminal Court. We further convey our nation's gratitude to the retiring judges for their illustrious service to the community of nations, and also thank the Assembly of States Parties for affirming the election of Ms. Sanyu Diana Awori as a member of the Committee on Budget and Finance for the period 2024 to 2026. Kenya reiterates its commitment and continued support to the work of the Committee on Budget and Finance. In that regard, we underscore that the committee's annual report is a critical accountability tool for the governance of the court. The report of the Committee on Budget and Finance has, in practice, formed the basis for political negotiations on the proposed budget of the court. Due to the seminal nature of the work of the CBF, Kenya urges that the states parties uphold with fidelity the widely accepted principle of equitable geographical representation in the composition of the CBF in order to remedy the current glaring anomaly in the underrepresentation of the African group. As we look into the future, we additionally propose a review of the funding guidelines so as to realize an equitable and sustainable funding of the court. A key plank of this endeavor should be a prudent approach towards the ballooning number of trust funds that target specific operations of the court and instead emphasize the traditional spheres of support, such as assessed contributions and support for the Trust Fund for Victims. Further, in strengthening the accountability framework of the court, we propose that these trust funds be subject to the consideration of the CBF and of the states parties. Madam President, Excellencies, the court has proposed the rollout of a tenure policy for staff at the level of P5 and above, commencing in 2024. Kenya supports a tenure policy that acknowledges geographical representation and gender balance, and which is executed in recognition of the primary objective of introducing fresh thinking and dynamism in the court. A key imperative for securing the independence of the court will be for this process to be implemented with these globally accepted and fundamental tenets in mind. Kenya will continue to promote the rule of law and to provide all necessary cooperation consistent with our domestic, regional, and international obligations as a state party. We note with satisfaction that the Kenya Witness Protection Agency continues to facilitate cooperation in carrying out measures aimed at facilitating special protection of threatened and/or intimidated witnesses to strengthen the regional and international criminal justice system. The process for the finalization of the draft Witness Protection Reciprocal Protection Arrangements Regulations 2022 is on course and within the current parliamentary calendar. On coming into force, the regulations are expected to provide for appropriate reciprocal witness protection arrangements with international courts, tribunals, commissions, institutions, and organizations. Madam President, we cannot conclude without recognizing the court's new registrar, Mr. Osvaldo Zavala Hirel, who took up office in April 2023. We look forward to working with him in fulfilling his high mandate. In conclusion, the Republic of Kenya urges all delegations to engage with each other, share past experiences, and build synergies, and in this way, continue to strengthen a court that serves the whole of humanity as envisaged by the Rome Statute. Thank you, Madam President.
I thank you for your statement, and now I give the floor to His Excellency Mr. Adam Koumisakis, Deputy Permanent Representative of Malta to the United Nations.
President, I am honored to address the Assembly of State Parties and would like to thank you, the Bureau, the Secretariat, and other facilitators in preparing and making necessary arrangements for this Assembly and for presenting us with renewed opportunities to strengthen the Court. Allow me to also pay tribute to the commitment and dedication shown by all officials of the Court over the past year, and not least by the President, the judges, the prosecutor, the registrar, and the deputy prosecutors. We join others in extending our warm congratulations to the newly elected judges, as well as to the registrar upon assuming his duties earlier this year. We wish to reassure him of Malta's unwavering support to the Court. President, at the outset, Malta fully aligns itself with the statement delivered by Spain on behalf of the European Union and its member states. This year we commemorated the 25th anniversary of the adoption of the Rome Statute, the founding treaty of the first permanent and independent international court, with the mandate to bring to justice the persons responsible for the most serious crimes of concern to the international community, individuals that courts are unable or unwilling to prosecute. We highlight that the primary responsibility of delivering criminal justice lies with us, state parties, and in this regard, we recognize the necessity for state parties to implement effective domestic legislation, which facilitates the implementation of the Rome Statute and full cooperation with the Court. There has never been a more pressing time for state parties to renew their commitment to the Court. The Court plays a critical role in ensuring accountability for the most atrocious crimes. Malta strongly condemns any threats and attacks against the Court and its officials, and reaffirms its full and unwavering support. Within this context, Malta firmly believes that the Court should be provided with all necessary resources and support to effectively fulfill its crucial mandate. President, as an elected member of the UN Security Council, Malta reiterates that the relationship between the Court and the Security Council calls for improvement. The Rome Statute empowers the Security Council to refer situations to the Court, but only 2 situations have been referred to date. There is a need for consistency and objectivity with respect to referrals. Moreover, the Security Council must ensure follow-up and call on the relevant states to cooperate with the Court. Malta remains fully committed to promote the principle of universality and emphasizes the importance of concerted effort and commitment, as well as continuous and meaningful dialogue. We take this opportunity to congratulate the Armenian government on depositing its instrument of ratification of the Rome Statute to the UN. Universality can be achieved through amplifying the trust of the international community in the judicial institution. In this regard, we are supportive of the need of a permanent due diligence process to ensure that only officials of the highest standard and moral character assume office. Malta reiterates that as state parties, we must also ensure that we give victims and survivors of atrocity crimes the recognition they deserve, and the survivors' voices are heard. We must continue to emphasize the salience of reparative justice, which is a key feature of the Rome Statute. In this regard, the Trust Fund for Victims has assisted thousands of victims with physical and psychological rehabilitation and material support. It is for this reason that this year Malta shall be making a voluntary contribution to the Trust Fund for Victims for the third consecutive year. Malta welcomes the Court's recent initiatives relating to addressing sexual and gender-based crimes, particularly the revision of the 2014 OTP policy paper on sexual and gender-based crimes, and the adoption of the OTP's policy paper on gender persecution. We believe that pursuing accountability for gender persecution holds enormous potential to address and prevent gender-based discrimination and unequal treatment, which is often at the root of these crimes. We also acknowledge that sexual and gender-based violence carries additional levels of trauma and stigma, and we must remain fully committed in supporting the Court's work done on this front. The Court must serve as an example of equitable geographic representation and gender balance. Therefore, we applaud its dedication to strengthen both aspects, which are crucial for ensuring that the Court reflects the global community it serves. President, in closing, Malta reiterates its resolute commitment to the Court, its values and its principles, and encourages fellow member states to look to the coming year with the aim of further strengthening the Court and reinforcing its role in ending impunity and bringing perpetrators of crimes under the Rome Statute to justice. I thank you.
I thank you for your statement. And now I give the floor to Mr. Bukavar Siddiqui Diarra, Secretary General of the Ministry of Justice and Human Rights of Mali.
Thank you. Madam President of the Assembly of States Parties to the Rome Statute, ladies and gentlemen, in your various capacities, all protocols observed at the beginning of my statement, I wish to recall that Mali is a state party to the Rome Statute, and we signed that statute on the 17th of July 1998 and ratified it on the 29th of May 2000. Mali also deposed its instrument of ratification on the 16th of August of 2000. Ladies and gentlemen, Mali cooperates with the International Criminal Court not only on the substance of the relevant provisions of the Rome Statute, but also based on the agreement on judicial cooperation with the Office of the Prosecutor signed on the 13th of February 2013, as well as the protocol agreement regarding the conditions for the establishment and the work of the ICC on the territory of Mali, dated the 5th of September 2014. Furthermore, we should also recall the agreement on the immunities and privileges ratified on the 8th of July of 2004, and the agreement on the execution of sentences signed on the 13th of January 2012. Furthermore, Mali made available to this august body a Malian citizen who was even the vice president of the ICC, and I'm thinking of the Honorable Madam Diarra Fatouma Dembele, which clearly demonstrated to the world that our country is chock full of competent human resources and upstanding resources who could serve both national and international justice. Ladies and gentlemen, based on Article 5 of the Rome Statute, International Criminal Code has jurisdiction to decide on crimes of genocide, crimes against humanity, war crimes, and crimes of aggression. According to the 10th adjective of the preamble and the first article of the statute, there is a complementarity between the International Criminal Court and national criminal jurisdictions. Pursuant to this principle, the ICC cannot prosecute and judge unless national criminal jurisdictions are lacking due to lack of determination to initiate an inquiry or procedures, or the ability to conduct successfully an inquiry or prosecution. This is the sacred principle of subsidiarity. It's important to indicate that the government of Mali very much interested in effectively combating impunity and strengthening the judicial framework and institutional framework in its fight against crime in all its forms by incorporating into its criminal code crimes that fall under the Rome Statute of the ICC, and also by establishing a special judicial department to combat terrorism and transnational organized crime with specific jurisdiction regarding these crimes. Ladies and gentlemen, it's important to underscore that the specialized judiciary department to combat terrorism and transnational organized crime systematically opens investigation in case of allegations of the violation of human rights. In fact, the prosecutor of the special judiciary department has already initiated judicial proceedings on allegations of violations of human rights for war crimes and crimes against humanity, which have been incorporated in our judicial proceedings and are envisioned and punished under Articles 29 and 31 of the Criminal Code. These proceedings are continuing, and the investigative magistrates that are in charge of these cases have been appointed as needed. All these activities are part of the effective implementation of the provisions of the Rome Statute of the International Criminal Court. Ladies and gentlemen, I wish to reaffirm to this august assembly the unshakable determination of my country to continue its full and comprehensive cooperation with the International Criminal Court, and the assurance that we do have capable and upstanding human resources to conduct the complex procedures that are necessary. Also, Mali would like to recall that the mission of the ICC is sacred as the highest jurisdiction against crime and various atrocities. But it should not be jurisdiction with political connotations at the service of the most developed or the most powerful nations. That is not the reason that led to its establishment. It must be impartial, and it must reassure the world by its rulings, by its actions and gestures, and not be enthralled to the most powerful or be a party to the global geopolitical war. Its well-being, its respectability, and its credibility will depend on this, undoubtedly. Its warrants should not be the swords of Damocles dependent on specific circumstances, and its rulings should not be rewards for services rendered. It's only on this condition that the hope created by the Nuremberg trials will not disappear. The world expects from the ICC objectivity, judicial integrity, and impartiality. Thank you very much.
Je vous remercie.
Thank you.
I invite Mr. Moussa Mohamed Moussa from the Permanent Mission of Djibouti to the United Nations.
Madame la Présidente.
Madam President, ladies and gentlemen, ministers, heads of delegation, ladies and gentlemen, friends, presidents, this year is nearing its end and has marked 25 years of the ICC. So for a quarter of a century now, my country, the Republic of Djibouti, has been alongside the other 123 countries that today make up the Assembly. And we took the path of collaboration, collective collaboration, in order to take action against the impunity of perpetrators of crimes that are injurious to the conscience of humanity. A quarter of a century ago, members of this august assembly decided to say no to barbarity. For a quarter of a century, we have been rising up against the idea that might is right and promoting the primacy of law on a global scale. For a quarter of a century, we, as states, decided to protect our common essence, our humanity. Madam President, the ICC has come a long way since its creation. Thanks to its existence, our grasp of the fight against impunity has been advanced. It is worth recalling that at Nuremberg we wanted to punish perpetrators in order to avoid executing them. In Rwanda and Yugoslavia, we emphasized prosecutions and sentencing. And at the ICC, it is total repression that we sought. From arrest to detention, it is the ICC that the people of the world look to in the hope of independent, impartial and fair justice. The ICC inspires small countries like mine in the belief that there is equality of treatment, and we are very proud to recall that former prosecutor, Madame Fatou Bensouda, through her actions, had shown that the protection of humanity was not just everybody's business, but the duty of each and every one of us. Through her actions, she tried to take the intangibility of the values that we share to their pinnacle. The deterrent reach of the court today is not to be denied. The court has carried out concrete actions towards universal application of the rule of law, and it is the fact that everybody adheres to the rules that gives them their legitimacy. For 25 years, this common project has continued to evolve in the face of the challenges faced. This was a result of our lack of experience when it comes to protecting the common interest. Madam President, we share your observation earlier this year that there is clearly a growing erosion of multilateralism and the primacy of law, and we therefore have to show greater commitment in order to ensure the universality and ensure that this is the case for the court. Multilateralism has shaped our international society. This situation is clearly seen in the fearfulness that characterize the determination of rules or the implementation of agreements and commitments on questions that have global reach. And we could look to the climate question, for instance. So what would then be the case for mass crimes? In recent cases, we have seen that it's not so much a crisis, but a process of transformation. Today, fearfulness, hesitation, and selectivity are characterizing our individual or collective positions on situations that fall under the Rome Statute, and this risks causing serious damage to the founding spirit and the collective conscience of our humanity that the ICC seeks to incarnate. The situation in Palestine is one of the most flagrant and worrying examples of this. Faced with humanitarian situations, grave violations of international humanitarian law and the Geneva Conventions, we must act to put an end to these atrocities, combat impunity, and identify those responsible. It is this conviction that drives my country, and it is for this reason that on the 17th of December, my country, the Republic of Djibouti, alongside South Africa, Bangladesh, Bolivia, and the Comores, we deferred the situation in Palestine to the prosecutor in accordance with Article 14 of the Rome Statute. We must now consider pursuing this transformation of multilateralism as a community of states. In other words, in order to achieve this universality that we so aspired to at the Rome Conference, and in order to do this, it is down to us, the states, to support the court and to prosecute any attempts to destabilize it. President, it is important for our Assembly to ensure that contributions are given so that the court can actually be beneficial to all of us in light of the global transformation that is currently occurring. We wish to share with all member states a number of suggestions in order to guarantee the implementation of all of the principles of the Rome Statute. First of all, it is more than urgent that the court, through the staff that make it up, for the court to be a fair reflection of the states and regional groups that were behind its creation. If urgent measures and immediate measures are not taken, this institution will to see a growing risk of a gap being created within the Assembly. Secondly, we must have true dialogue with regional organisations that today constitute the path towards a better defined universality. This is the best way to overcome fears as regards the aims of the court and to root its action in all regions of the world. Thirdly, we should think about current and future challenges and avoid international criminal justice being a responsive or reactive justice. This thinking would help us think about our past actions and facilitate the work of the court. As in Rome, it is down to us to go beyond our contradictions and to make progress on the path to the primacy and effective implementation of the international legal arsenal. I thank you.
Now I invite His Excellency Mr. Ivan Simonovic, Permanent Representative of Croatia to the United Nations.
Madam President, I use this opportunity to express Croatia's gratitude to the President of the Assembly and the members of the Bureau for their important work, and we are looking forward to be working with new members. I also congratulate the newly elected judges. Croatia aligns itself with the statement delivered on behalf of the EU and its member states, and I would like to add some remarks in my national capacity. Madam President, trends are negative. Around the world, atrocity crimes and their victims are on the rise. Accountability is the best form of their prevention. Marking the 25th anniversary of the adoption of the Rome Statute, Croatia reiterates its strong support for the International Criminal Court, the first permanent international judicial body in the pursuit of criminal justice. In order to be able to deliver on its mandate, the court must be protected from outside interference and pressure. Protecting the neutrality and judicial independence of the court is paramount to its proper functioning. In addition, to ensure legitimacy of the court, it is important to continue appointing the mostly highly qualified judges to the court through merit-based elections. Madam President, the Rome Statute embodies the conviction that most serious crimes of international concern must not go unpunished. The way forward is to make the Rome Statute system stronger and more effective. Hence, we attach great importance to reviewing the Rome Statute regarding the jurisdictional limitations for the crime of aggression. To Croatia, the crime of aggression has a special significance. Because of the 90s, we suffered aggression ourselves, accompanied by war crimes and crimes against humanity. We urge all those states that have not yet done so to ratify the Rome Statute and all its amendments. We firmly believe that the efforts to promote the universality of the Rome Statute can contribute to the prevention of mass atrocities. We also highlight that the role of the ICC is to complement instead of replace existing national judicial systems. Therefore, all state parties need to adopt effective national legislation to implement the Rome Statute and to reinforce their national capacities. It is important that the Court continues to cooperate closely with other international mechanisms established to ascertain facts related to alleged violations of international human rights law and international humanitarian law. We will continue to support various efforts to gather evidence, facilitating future legal action. Madam President, the fight against impunity is crucial for the prevention of atrocity crimes and for providing justice for the victims. In these challenging times, we should redouble our efforts to make ICC truly universal and resilient. I thank you.
I thank you. And now I give the floor to His Excellency Mr. Pa Musa Jobarte, Ambassador of Gambia to Brussels and Permanent Representative to the International Criminal Court.
Good afternoon, and thank you, Madam President. Madam President, Excellencies, distinguished delegates, it's an honor to address the 22nd Assembly of State Parties. I wish to express my appreciation to the Secretariat for the commitment and dedicated service they continue to devote to the discharge of the functions of the court. Madam President, allow me to first convey the Gambia government's renewed commitment and unwavering support to the International Criminal Court. The importance of the court cannot be overstated, especially within the context of the current geopolitical and security challenges we are facing. The 22nd session of the ASP must mark a milestone and call for renewed optimism for the future of the court. We must not relent in our moral and legal obligations to end impunity in all its forms and manifestations. There is no other independent international criminal court other than the ICC, which has been established to serve as a court of last resort, to hold individuals accountable, and to serve as a deterrent. Madam President, the Gambia recognizes the progress the court continues to make in the execution of its mandate, as well as the challenges it encounters. In this connection, we continue to appreciate the report of the Independent Review Committee for their impartial recommendations, which have significantly enhanced the performance and efficiency of the court. The Gambia continues to stand by the values of the court as one that represents justice for all victims of atrocity crimes, anywhere, irrespective of race, creed, or color. Madam President, you may recall that the Gambia recently concluded its Truth, Reconciliation and Repatriation Commission, the TRRC, which addressed human rights violations committed during the 22 years of dictatorship under the former government. The recommendations of the Commission were accepted by the government and widely shared with partners. As part of its Truth Commission report implementation plan, the Gambia is in the process of establishing a hybrid court as one of the preferred options to address atrocity crimes recommended for prosecution by the Commission. We strongly believe that the Gambia would be better placed and well enhanced by the capacity building opportunities and resources available at the court to support such a hybrid court. By providing such support, the court will fulfill its complementarity principles for a state that is willing and capable to prosecute atrocity crimes and to address impunity in a judicious manner. It is against this backdrop that we call on the court to improve cooperation with states, in particular those in the developing world, by bridging the gap through continued dialogue and enhanced but differentiated engagements. Capacity building is a relevant area in this regard. It will be recalled that the pillars of the court are in tandem with the principles of complementarity, cooperation, independence, and impartiality. To this end, the Gambia reiterates its call to the court to redouble its efforts in building the capacity of national judges, prosecutors, magistrates, and others in the domestic judicial system of state parties. Madam President, we are convinced that with the appropriate capacity building and access to plethora of resources available at the disposal of the court, we will certainly equip and improve national justice systems to prosecute and punish atrocity crimes. The complementary principle of the court, as envisaged in the Rome Statute, will be redundant where the court is seen to use up the role of domestic courts instead of being the court of last resort. Madam President, we encourage the court to always maintain impartiality during the most difficult periods and circumstances. The court must be seen to be decisive in its decision-making. The court must always be seen to espouse its values, particularly in times when the world is at crossroads and looking for leadership from the court. The Gambia, therefore, urges the court to fulfill its responsibility and reject all forms of selectivity in the application of international legal and moral standards, and not ignore atrocity crimes anywhere and wherever they are committed. The court needs to do more in its efforts to amass maximum support and trust around the world. In this endeavor, the Gambia supports the continued work of the court to further develop the contents of the secure platform and cooperation, to hold consultation on advisability of developing regional thematic focal point and cooperation, to creating a permanent structure for a network of national practitioners and focal points and cooperation, and on the deepening of the relationship between the UN and its agencies and entities, including for capacity building purposes, in order to foster cooperation with the court. In conclusion, Madam President, the government of the Gambia reiterates its continued support to the court and the efforts leading to the realization of the universality of the Rome Statute. The court must therefore be seen to consider concerns raised in national statements and establish mechanisms for the court to address such concerns. States must be assured that all their views and concerns are taken into consideration in relation to equitable geographic representation of all regions in every facet of the court. Trust in the court must be reassured through bilateral and multilateral engagements with a view to ending mistrust in order to achieve the ultimate goal of the court, which is universality. I thank you for your kind attention. Thank you.
I thank you for your statement. And now I invite Su Excelencia, Señora Griselda.
Now I invite the Permanent Representative of El Salvador, Ms. Griselda Araceli Gonzalez Lopez, to speak. Madam, thank you very much. Madam, authorities of the court, Your Excellencies, representatives of civil society, allow me to express the sincere gratitude of my delegation for the important work carried out by Dr. Silvia Fernandez Gurmendi, who as president of the Bureau of the Assembly of States Parties is successfully completing the 3 years of its mandate, which it has exercised effectively with leadership representing the Latin American and Caribbean group in the various activities of this organ of the International Criminal Court system. Faithful to its commitment to the international criminal justice system, El Salvador reiterates its strong condemnation to any criminal activities that violates the principles of peaceful coexistence in the international community, including any crimes against humanity and war crimes. These, due to their scale and horrific nature, indicate an absolute disregard for human dignity and fundamental human rights. This is why the strengthening of preventive measures at the national level, as well as the commitment to intensify international cooperation to ensure access to justice, are extremely important in this task. My delegation, in this opportunity, renews its wholehearted support to the International Criminal Court as an institution that is permanent, independent, and with a universal mission. And this by exercising and strictly adhering to the principles of subsidiarity of national jurisdiction, is working to eliminate cases of impunity when such crimes are committed. Madam President, while acknowledging and congratulating the election of the 6 new magistrates of the International Criminal Court, my delegation would encourage them to adhere to a firm commitment to preserve the impartial, independent, and universal work of the court, based on an approach that seeks to strengthen the methods of work in its judicial function, as well as a guardian of the rights and guarantees of victims and witnesses, and also to adapt to the reality of new technologies of information and communication and their impact on the process of international criminal justice, as well as focus on the promotion of gender equality in their work. The promotion of institutional strengthening of the system established based on the provisions of the Rome Statute, and in particular the mandates adopted by the Assembly of States Parties, is something that we should preserve and strengthen. As far as the consideration of the methods of work of the Assembly of States Parties, El Salvador would like to join its voice to the need that the Bureau maintains the representative character in its compositions by ensuring equitable geographical distribution and appropriate representation of the main legal systems of the world. In line with what I've just said, we have supported the joint proposal on strengthening the International Criminal Court and the Assembly of States Parties, which requests the Bureau to present a written report in consultation with all states parties, the court, and civil society in order to identify the best form of implementing this mandate. Bearing that in mind, my delegation hopes that true gender parity is ensured and would urge the Bureau to continue working on this matter in future sessions. Now, I'd like to express the gratitude of El Salvador for the dedication and the efforts of the review mechanism of the International Criminal Court system over the past 3 years, which was led by the ambassador of the Kingdom of the Netherlands and of Sierra Leone, as well as focal points of Bangladesh, Chile, and Poland. Acknowledging that the final decision on the future of the mechanism will depend on member states, my delegation would urge all delegations to ensure the continuity of the work of this mechanism, and especially the effective implementation of the recommendations of the independent expert review, and especially those recommendations geared towards strengthening the Secretariat of the Trust Fund for Victims and the main goals aimed at reparations, as well as other programs for the benefit of victims. Also, the visibility and financial resilience, as well as the exchange of knowledge and experiences and organizational performance. Now, for the effective comprehensive reparation of victims, the mobilization of resources is very valuable. However, even more, what's important is the appropriate support and management of psychosocial practices that make it possible to ensure truly comprehensive well-being to victims. Knowledge and interconnection between regional systems of human rights could be a practice that could benefit and could be replicated in the system of international criminal justice. Now, on the program and budget of 2024, my delegation reiterates the importance that all programs of the court should strengthen measures geared towards the effectiveness, transparency, and the rational use of resources in a proportional and effective way. We would urge that the future work of the Committee, the Budget and Finances of this Assembly draw up recommendations that identify, based on technical criteria, the allocation of resources and reduction of costs in budgetary lines that during the process of negotiations have shown figures that are not in line with a policy of streamlining and rationality that should prevail in the work of the court. Furthermore, the measures for the effective use of resources should be implemented based on ensuring operational arrangements and program and financial opportunities that maintain current programs, and also they should consider the possibility of launching projects that ensure the comprehensive reparation of victims, and not just with the financial resources derived from the trust fund, and that include other forms of reparation that are geared towards ensuring the comprehensive well-being and psychosocial support of victims. El Salvador has a responsible approach regarding its national priorities, and in line with the economic and financial realities of the world, has maintained a zero-growth policy with regard to its contributions to all international organizations. Based on that, we'd like to reiterate our appeal to avoid excessive increases in the budget of the court, and we would actually urge that other alternatives are sought to highlight the transparency and budgetary effectiveness. The appropriate allocation of resources for strengthening systems and measures of cybersecurity is a task that the Secretariat of the Court should really focus on, especially in the face of recent challenges that have had a significant impact on the operation of the Court, on its digital infrastructure, as well as the protection of systems of information and data, which were made vulnerable due to the cyber attack that was detected in September of this year. El Salvador acknowledges that the opening of new investigations by the prosecutor leads to an increase in the the work burden and requires hiring personnel with the new skills. However, it's important that these investigations are carried out in the framework of the existing regular budget in a sustainable way while maintaining the integrity of the system of the International Criminal Court and reducing as much as possible the dependence on voluntary contributions. I'd like to reiterate the readiness of my country to continue participating in a constructive way in searching for a consensus for the adoption of the 2024 budget. Madam President, and this year we commemorate the 25th anniversary of the adoption of the Rome Statute. 2023 has been a year in which the court has had the greatest visibility since its creation, and together with this milestone, it is also confronting a series of challenges, in the face of which it is essential to strengthen the criteria of impartiality and independence of the work of the court, as well as the protection of its institutions, its magistrates, its staff members, personnel, and all the personnel established by these under the Rome Statute in general. In conclusion, I'd like to reiterate the commitment of El Salvador to continue supporting and defending the principles enshrined in the Rome Statute, as well as preserving the integrity of the court as a system of international criminal justice established based on its statute, with the purpose of ensuring that the perpetrators of the most serious crimes of international significance are brought to justice, as well as that the victims and witnesses of these crimes receive the greatest possible protection. Thank you very much, Madam President. Thank you very much.
Invite His Excellency Mr. Umaru Ganu, Permanent Representative of Burkina Faso to the United Nations.
Merci, Madame la Présidente.
Thank you, Madam President. President, Excellencies, ladies and gentlemen, distinguished delegates, at the outset, Burkina Faso wishes to commend the outgoing President, Madame Silvia Fernandez de Gourmendi, for the enormous amount of work that has been accomplished under her leadership. At the same time, we congratulate the incumbent Madame Paivi Kokoranta for her election, as well as all the members of the Bureau. Please be assured of the full support of the delegation of Burkina Faso. We have just elected 6 new judges to the court, and at this time I would like to join my predecessors in congratulating them on behalf of my delegation and wish them the very success as they execute their high mandate. This is also an opportunity for Burkina Faso to thank all states who supported our candidate to the role of judge at the court. Madam President, this 22nd session of our Assembly is occurring at a juncture that is marked by multifaceted challenges, notably as regards the fight against impunity for crimes under the jurisdiction of the court. It is essential for the court to work on strengthening trust and cooperation with states parties by working to overcome and lift any suspicions of manipulation, partiality or selectivity in the treatment of cases where there have been proven grave violations of human rights. This means that the question of the independence of the ICC is primordial when it comes to guaranteeing its credibility. My delegation feels that the court, which is evolving in an international environment facing multiple and multifaceted challenges, and it owes it to itself to take account of the views and recommendations of its member states in its quest to reconcile the imperatives of justice and peace. In the Sahel in particular, and in Burkina Faso specifically, the macabre and treacherous actions of terrorist groups has led to a security crisis that is unprecedented, together with its share of victims, civilian and military, and many internally displaced persons. Burkina Faso wishes to avail itself of this opportunity at this general debate to reiterate our commitment to the rule of law, to respect for human rights, and to the principles of the Rome Statute. My country incorporated the Rome Statute in 2009, together with its amendments. A law adopted on the 3rd of December 2009 designated the General Prosecutor of the Court of Appeal of Ouagadougou as the focal point for the ICC, despite the difficulties that our country has been facing as a result of the terrorist attacks that we've been experiencing for 8 years. Burkina Faso continues to cooperate with the court. Given and bearing in mind the principle of complementarity and that it is an essential pillar of the ICC, the legislature of Burkina Faso has given competency to national jurisdictions to identify international crimes regardless of the place where they are committed, the nationality of the perpetrators, when the alleged culprit is present on national territory. The current session is taking place as we celebrate 25 years since the adoption of the Rome Statute. This occasion is the opportunity to recognize how far we have come over the years and also to consider the challenges that we all face as supporters of the court. First of all is the question of its budget. My delegation in this regard wishes for the exchanges on the draft budget to actually be agreed by consensus in order to equip the court with the necessary resources to allow it to fulfill its mandate adequately. And then there is the question of the legal framework of the court and its universality. And in this regard, the ratification of the Rome Statute by Armenia this year should be commended. In order to maintain this momentum, it is desirable for cooperation between the court and the United Nations to be strengthened and for dialogue between the ICC and all states be extended as appropriate. Finally, Madam President, Burkina Faso reiterates its commitment to the court and to combating impunity for the gravest crimes. I thank you. I thank you.
Señor José Eduardo Pereira Sosa, chargé d'affaires de la mission permanente.
I invite the Chargé d'Affaires of the Permanent Mission of Paraguay to the United Nations.
Señora Presidenta.
Madam President of the Assembly of the States Parties of the Rome Statute, Your Excellencies, distinguished colleagues. Thank you very much for giving me the floor. First of all, on behalf of my own delegation, I'd like to thank the work of the President, Silvia Fernandez Gurmendi, for her commitment to being in charge of the processes carried out by the Assembly. Her experience and knowledge have been extremely important in our work over the past few years. I would also like to congratulate the new President of the Assembly, Paivi Kaukoranta, on her election, and express the support of my delegation to her important work. And we'd also like to express our congratulations to the entire Bureau. We believe that the skills and capacity of all its members will contribute to carrying out their work constructively, bearing in mind the broad range of substantive topics that they have to work on today and in the future. My delegation would like to highlight the volume of work and the tireless efforts of the court and the Office of the Prosecutor. The adoption of a large number of rulings and over 200 hearings this year point to the relevance and the scope of the work of the ICC in its efforts to ensure reparation to victims and respect for the principles of international law, as well as to prosecute and judge the most serious crimes that affect international community as a whole. This is why we advocate in favor of achieving the goal of universality of the Rome Statute. And bearing that in mind, Paraguay acknowledges the importance of the International Criminal Court as a system of permanent system of justice. This is based on its complementarity with national criminal law, and it constitutes an essential tool to confront impunity in the most serious and horrific crimes. We acknowledge the importance of the adoption of the strategic plans that will guide the actions of the court, the Office of the Prosecutor, the Registrar, and the Trust Fund for the years 2023 to 2025. We hope that the elaboration of these plans will also promote the synergies that are necessary to facilitate the effective work of the Rome Statute system. Madam President, Paraguay, in line with its constitution, acknowledges and accepts the fundamental principles of international law, ensuring respect for human rights and declaring that certain horrific crimes have no statute of limitations. This is why we support the coherent implementation of the mandate of the court in all situations and cases under its jurisdiction, in the interests of justice and the rights of victims to have access to justice. We'd like to also stress the need for sustainable resources for all to deal with all situations and cases, as well as the need for cooperation with the court in its investigative work. We're also in favor of strengthening the independence and judicial impartiality of the court. These principles, which are extremely important in a rule of law, both at the national and international level, are essential pillars in the work of the court. In this context, the International Criminal Court, as a defender of the fundamental values of the international community, requires our joint efforts to strengthen its institutionality and ensure that the exercise of its mandate takes place to the highest standards of professionalism, independence, and impartiality. In a world full of conflicts, the work of the court must be focused on compliance with a mandate enshrined in this Rome Statute, and through this assembly to reconfirm its commitment to multilateralism and respect for international law. Lastly, my delegation is in favor of strengthening a constructive dialogue with the United Nations, including with the Security Council and with states parties and with non-governmental organizations and with civil society. This kind of dialogue will contribute to consolidate the goals established in the Rome Statute, thus promoting strengthening of international justice and bolstering the achievement of success in the fight against impunity and the search for justice for victims of the most horrific crimes. Thank you very much.
I invite His Excellency Mr. Muhammad Abdul Muhit, Permanent Representative of Bangladesh to the United Nations.
Madam President, at the outset, I wish to congratulate you for your able leadership of this session of the Assembly of the State Parties. We would also like to register our deep appreciations to the Office of the Prosecutor and the Registry for their dedicated service to the court. We take this opportunity to also warmly congratulate the newly elected judges of the court, the new President of the Assembly and the Bureau members, and assure them of our full cooperation and support in discharging their responsibilities. Madam President, as a victim of genocide, war crimes, and crime against humanity itself, Bangladesh remains deeply committed to the principles and purposes of the Rome Statute. We believe that the International Criminal Court has the potential to advance the global commitment to end impunity and prevent occurrence of the most serious crimes under international law. We join others in reiterating our strong support for the integrity and independence of the court, and condemn any external attacks, interference, and politicization that might impede the efforts of the court to fulfill its mandate. Madam President, allow me to share a few specific points. First, we believe the credibility of the court lies primarily in its ability to serve the victims, particularly those who are most vulnerable and the least heard. In this regard, we wish to refer to the situation of Rohingya Muslims of Myanmar, who are considered as one of the most persecuted communities in the world. Bangladesh is currently hosting over 1 million Rohingya Muslims who were forcibly displaced from their homes in Myanmar. We thank the Office of Prosecutor for its ongoing investigations on this question, to which our government is extending full cooperation. We hope to see early completion of the investigation, which is critical for ending the long-standing culture of impunity in Myanmar and supporting the right of Rohingyas to seek safe, voluntary, and dignified return to their homeland.
Second, as a criminal court, ICC's services are meant to deter the perpetrators from continuing or recommitting the crimes under its jurisdiction. It is therefore critically important that ICC remains objective in its attention to the protracted or long-standing situations. We are deeply concerned by the failure of the ICC to make any progress in the investigation in Palestine situation, which has only emboldened the State of Israel to continue its atrocity unabated in the occupied Palestinian territory. In the context of the ongoing Israeli aggression and atrocities in Gaza, Bangladesh, along with 4 other countries, has made a referral to the ICC seeking investigation by the Office of the Prosecutor about possible commission of genocide, war crimes, and crimes against humanity in the OPT. We call upon the Prosecutor's Office to prioritize this investigation with the view to preventing continuation of Israel's genocidal actions in Gaza. Third, the mandate and responsibility of ICC to punish the most serious crimes can be better materialized by effective use of its complementarity principle. Bangladesh has already benefited from this principle as it took up the mammoth task of trying individuals responsible for genocide, crimes against humanity, and other serious international crimes committed during its 1970 War of Liberation. The trial, despite many challenges, has succeeded to set a good example of prosecuting international crimes through national courts. Bangladesh calls for enhanced institutional arrangements for disseminating ICC's norms and practices with interested national jurisdictions for further strengthening complementarity, bearing in mind the varied context of national jurisdictions. In addition to that, we also emphasize the importance of expanding ICC's technical cooperation capacity, particularly in the area of victim and witness protection. Fourth, as a state party of the ICC, we wish to see an effective governance system in the court that maintains the principles and practices of a member state-driven intergovernmental organization. In this regard, we welcome the review activities undertaken by the ASP and the court and call for further efforts in this regard. We are particularly keen to see the court to uphold geographical representation and gender balance in its structure and urge for all possible efforts towards addressing the gaps in equitable geographical representation. Finally, as we observe the 25th anniversary of the court, we cannot overemphasize the importance of promoting universality of the Rome Statute. We welcome the decision of Armenia to join ICC as a new member. However, we cannot be complacent as almost 1/3 of the UN's membership is yet to join the court, including countries with global clout. As states parties, we have a responsibility to encourage other states to join the Rome Statute. At the same time, the ICC must also demonstrate through its actions that it is capable of delivering justice to the victims and holding the perpetrators accountable, no matter who they are. To conclude, Madam President, I reiterate our country's firm and unequivocal support to the ICC and our commitment to work with fellow state parties in building a world that is just, equal, and free from impunity. I thank you.
I thank you. Now we have concluded the statements by state parties representatives. I thank all speakers for their statements and support pledged for the court. On the basis of previous Assembly decisions, the Bureau recommended that the Assembly allocate 45 minutes for the participation in the general debate of observers pursuant to Rule 92 of the Rules of Procedure of the Assembly. We will start with a statement by Her Excellency Ms. Beth Van Schaak, Ambassador at Large for Global Criminal Justice of the United States of America.
Madam President, esteemed colleagues, I'm really honored to address you here today as the United States Observer Delegation. I first want to congratulate those of you who have been elected to important positions in the court, and to thank those who are transitioning out for new endeavors, for their incredible service to this institution. Congratulations also to Armenia to taking steps to become the newest state party to the Rome Statute. On that note, we want to acknowledge all the many contributions that Assemblies of States Parties members have made, and many of you personally. We know that without your work, this institution could not carry out its essential mandate. This includes your investment of countless hours devoted to governance and the review process, your concrete cooperation in many areas of the court's work, and your efforts to ensure steady funding. States' multifaceted investments in the court evince a faith in the institution and the role of criminal accountability in addressing conflicts around the world and delivering justice to victims of the most serious crimes known to humankind. I also want to commend the court for its achievements over the past year. The court continues to demonstrate that it is an essential component of an ecosystem of international justice. This past year, we welcomed progress in the Anguen and Al-Hassan cases, the court's reauthorization of the investigation in Venezuela, the court's arrest warrants for Vladimir Putin and Maria Lvova-Belova for acts that are violations of the Fourth Geneva Convention. We're also very pleased to see the ICC's meaningful progress in the first trial following a Security Council referral in the case against a former Janjaweed commander. We concur with the prosecutor's conclusion that the ongoing situation in Darfur is a product of years of impunity, and we welcomed the decision to commence focused investigations into current events. Indeed, just yesterday, U.S. Secretary of State Antony Blinken released his determination that the Rapid Support Forces and the Sudanese armed forces have committed war crimes in Sudan, and that the RSF and allied militia have committed crimes against humanity and are responsible for ethnic cleansing in Darfur. The atrocities occurring today in Darfur are an ominous reminder of the prior genocide, in that they involve so many of the same perpetrators, the same communities being targeted, and the same patterns of criminality. Like so many of you here, we are dismayed by the violence elsewhere, including in Ukraine, in Syria, and now in Israel and Gaza. In addition, around the world, entire communities are oppressed because of their identity or their faith, as in Xinjiang or Myanmar, or because they seek to express a disfavored political opinion, as in Venezuela or Belarus. We are doing what we can in many of these situations to ensure good faith efforts towards a just and lasting peace, respond to the dire humanitarian situation on the ground, ensure robust and accurate documentation of what is happening and who is responsible, encouraging the warring parties to faithfully adhere to their legal obligations, and forge pathways to justice. We know that responding meaningfully to demands for justice is not only an important objective in its own right, but is a core element of a sustainable peace. This recognition is embodied in the Rome Statute itself. Last year at this gathering, I described our progress implementing President Biden's reset of the U.S. relationship with the ICC. Since then, we have worked to put this relationship on a sustainable path. For example, we are able to provide practical assistance to the OTP across a range of its investigations. We're helping the court track fugitives across several situations, including by offering rewards for their arrest. We're providing input and commentary on the OTP's policy papers around gender-based violence. We are convening meetings from experts from the U.S. government, Silicon Valley, the court, and other accountability mechanisms to identify practical solutions to some of the most difficult challenges facing international justice actors today, including with respect to witness protection, insider witnesses, and cybersecurity. Finally, we have been pleased to help facilitate engagements between Washington and The Hague. This includes visits to the court by bipartisan members of Congress and their staff, and Attorney General Merrick Garland, the first by a cabinet-level official. These interactions have helped to foster a greater understanding of the ICC in the United States and are building connections across the various branches of government with the court. In addition, and in line with the principle of complementarity, the United States is pursuing a broad range of initiatives to strengthen the underlying objectives of the Rome Statute system and to support accountability for atrocity crimes globally. To this end, we are catalyzing strategic litigation in courts around the world. We are investing in the physical, psychological, social, and financial rehabilitation of victims and survivors as expressions of solidarity, but also as a legal imperative. And we are looking for ways to track, constrain, and ultimately bring into custody perpetrators, including using our rewards program and our sanctions authorities. We have also updated our own laws to close the impunity gap for accused war criminals. Just yesterday, the Department of Justice announced the first indictments under our War Crimes Act against 4 Russian-affiliated militia members for war crimes against a U.S. citizen in Ukraine. In closing, I want to acknowledge that another essential component of these efforts is to be self-critical. We cannot advance justice abroad if we do not confront justice and injustice at home. We know that, and we take very seriously allegations of misconduct by U.S. personnel, but also legacies of harm to communities of color and others within our community. As Vice President Harris has noted, we know our work at home will make us stronger for the world. Esteemed colleagues, and in conclusion, the United States pledges to enhance our efforts on all of these fronts, including through robust engagement and cooperation with the court and with friends of the court, parties and non-parties alike. We know that our efforts are all the more powerful by standing with all of you, the community of states and advocates committed to global justice. Thank you.
Thank you. I thank you for your statement. And now I invite Her Excellency, Ms. Zara Ershadi, Ambassador and Deputy Permanent Representative of Iran to the United Nations.
Bismillah ar-Rahman ar-Rahim. Madam President, Excellencies, distinguished delegates. At the outset, I would like to commend and appreciate the Presidency, the judges, the prosecutor, the registrar, and all the staff members of the International Criminal Court who have worked tirelessly to ensure that the ICC continues to fulfill its role to put an end to impunity for the perpetrators of the most serious crimes of concern to the international community as a whole. I would also like to thank the Bureau and the Secretariat of the Assembly of the State Parties to the Rome Statute for the preparation of the 22nd session and the related documents. Madam President, on the occasion of the 25th anniversary of the adoption of the Rome Statute, the world has shockingly witnessed the preparation of atrocity crimes by the Israeli occupying regime against the Palestinian people in the Gaza Strip. Over the recent days, the Israeli carpet aerial bombing and ground invasion against Gaza have caused the killing of more than 17,000 innocent people, more than 45,000 are wounded, and more than 7,000 are missing under the rubble, presumably dead. Half of the enclave is leveled, with no place being spared. Hospitals, mosques, churches, schools, and other purely civilian infrastructure have not been immune, with many hundreds of people being brutally slaughtered inside these places. In fact, no quarter is given. The atrocity committed during the past weeks evidently include all the constituting elements of the most serious crimes, including war crimes, genocide, and crimes against humanity. This is while, after nearly a decade, the case regarding the situation in the state of Palestine for atrocities committed in the occupied Palestinian territory, including East Jerusalem, is open before the ICC without any tangible progress. Right at this stage of history, Madam President, there is unprecedented attention toward the ICC across the world, and the expectations of the international community for the ICC are greater than ever. Therefore, it is crucial that the Court applies the same level of attention, activity, and resources it applies to other situations, to the situation in Palestine, to avoid perception of double standards and selective justice, and to refuse judicial politicization of the proceeding. The Court is expected not to let perpetrators of these heinous crimes go unpunished. A whole nation that has been subject to oppressive occupation for 75 years is on the verge of genocide and extermination. Every day that passes without accountability, innocent civilians, including children and women, are being killed and slaughtered, with their lands being confiscated and their homes getting destroyed. Madam President, let me underline that we cannot lose sight of the principle of complementarity upon which is the cornerstone of the Rome Statute. For the sake of functionality and efficiency, the Islamic Republic of Iran firmly urges the Court to prioritize and address the outstanding cases before it, rather than increase its docket with cases that could be dealt with more efficiently and effectively at the domestic level. The principle of complementarity is fundamental to the Court's core mandate as a court of last resort in investigating and prosecuting serious international crimes unless state parties are unable or unwilling to do so. Speaking of unwillingness, it seems that the shameless impunity provided to Israel by its supporters and enablers has always emboldened the occupying regime to continue its atrocity crimes with an absolute sense of comfort. Nevertheless, the court must demonstrate whether ICC is an independent and impartial international criminal court in combating impunity and upholding the rules-based order. The court must decide whether it tends to vigorously resist the bullying of certain states and act in the interest of justice and accountability similar to other situations and cases, or rather tends to step back and let the atrocities committed by the occupier forces in the respective situation go unpunished. My delegation urges the court to take every measure at its disposal to urgently launch an investigation into the recent catastrophic humanitarian situation in the Gaza Strip and urges the ICC prosecutor to expedite its activities, prioritize investigations, and provide all facilitation in this regard to put an end to impunity for the perpetrators of these crimes. The swift and unwavering action by the court will work as an important deterrence for further atrocities and will prevent the killing and slaughtering of hundreds of innocent civilians, including children and women. However, the recent referral of the situation in Palestine on behalf of South Africa, Bangladesh, Bolivia, Comoros, and Djibouti, in accordance with the Article 13A and Article 14 of the Rome Statute, could be considered as an important step in this regard. Madam President, in the same vein, the Islamic Republic of Iran remains seriously concerned by the situation in the Islamic Republic of Afghanistan that remains outstanding before the court. My delegation would like to reiterate the necessity of having a comprehensive view of the crimes committed in the situation of Afghanistan, and not merely limiting the investigations to one party of the conflict or to a specified period of time which excludes several essential events in this situation. We deem it appropriate that the Office of the Prosecutor take into consideration its previous findings in the situation of Afghanistan comprehensively, and that the Appeals Chamber judgment on 4 April 2023 amended the decision of Pretrial Chamber 2 in relation to crimes committed on the territory of Afghanistan since the 1st May 2003, as well as the court's decision to investigate and prosecute crimes that have a nexus to the armed conflict in Afghanistan, are sufficiently linked to the situation and were committed in the period since the 1st July 2002. It is highly expected that those military forces who committed war crimes in Afghanistan be held accountable and face punishment. Madam President, the international community has a shared responsibility to maintain justice and to prevent impunity. On that account, the Islamic Republic of Iran supports the efforts of the international community to punish the atrocity crimes, promote and realize judicial justice, and to closely follow the activities of the ICC, and in particular, the situation of Palestine and Afghanistan. I thank you.
I thank you, and now I invite Mr. Li Lin of the Permanent Mission of China to the United Nations.
Madam President, it's an honor and a privilege for me to address the meeting on behalf of China. The Chinese government always attaches great importance to the prevention and punishment of serious crimes, actively participating in relevant international efforts in accordance with international law. China closely follows activities of the ICC and has participated in successive sessions of Assembly of State Parties to the Rome Statute as an observer state. The Chinese observer delegation listened attentively to the report presented by the President of the Court, as well as to the views expressed during the general debate. China noted the efforts made by the Court in investigation, trial, repatriation to victims, and cooperation with relevant countries and international organizations. This year marks the 25th anniversary of the adoption of the Rome Statute, which provides a good opportunity to learn from lessons and reflect on the work of the ICC. In the face of the complex and volatile international situation, the international community expects the courts to adhere to the mandate of the Rome Statute, strictly follow the principles of complementarity and international cooperation, determine its jurisdiction of situations independently, objectively, and impartially, carry out investigations and judicial proceedings in accordance with international law, interpret and apply the Rome Statute and the general international law in an accurate, bona fide manner and with uniform standards, so as to play a constructive role in appropriately resolving relevant issues. China knows that the prosecutor announced that he is moving forward with the investigation of the situation of the state of Palestine, which was opened in 2021, and that it will cover any crimes committed on the territory of Palestinians by any party in the current conflict. The current Palestinian-Israeli conflict has caused enormous civilian casualties and a humanitarian disaster, which is a matter of great concern to the international community. South Africa and other 4 state parties referred the situation of the state of Palestine to the prosecutor last month. China expects the court to exercise its power in accordance with international law and to avoid politicization and double standards. At the end of last month, the Foreign Minister Wang Yi, member of the Political Bureau of the Central Committee of the Communist Party of China, chaired the Security Council high-level meeting on the Palestinian-Israeli issue, which facilitated the independent exchanges among relevant parties and contributed to the building up of consensus. China also submitted the position paper on resolving the Palestinian-Israeli conflict, which offered 5 proposals implementing a comprehensive ceasefire and ending the fighting, protecting civilians effectively, ensuring humanitarian assistance, and enhancing diplomatic mediation, seeking political settlement. As a permanent member of the Security Council, China will continue to work with other states to achieve the end of hostilities, protect civilians, and ultimately promote a comprehensive, just, and lasting resolution to the question of Palestine through the 2-state solution. China would like to reiterate here the importance of the principle of the immunity of state officials. Under general international law, incumbent heads of states enjoy absolute and inviolable immunity from criminal jurisdiction. Paragraph 2, Article 27 of the Rome Statute provides that impunity of state officials shall not bar the court from exercising its jurisdiction over such a person. This provision applied only to state parties and could not ban upon non-state parties. Otherwise, it would be contrary to the principle that a treaty does not apply to a third party without its consent. At the same time, Article 98 of the Rome Statute provides that the court may not proceed with a request for surrender or assistance, which would require the requested state to act inconsistently with its obligations under international law, with respect to the state or diplomatic immunity of a person or property of a third state. This provision, which recognizes and guarantees the immunity of state officials under general international law, should be observed by the court as well as by state parties to the Rome Statute. Only in strict compliance with the Rome Statute and general international law and effective respect for the jurisdictional immunity of head of state would make it possible to maintain stable interstate relations so as to achieve sustainable peace. Madam President, the allegation of genocide and crimes against humanity in Xinjiang is nothing but completely lying. Today's Xinjiang enjoys social stability, economic development, ethnic solidarity, and religious harmony, and rising living standards. Peoples of all ethnic groups work in peace and happiness. These are objective facts that cannot be distorted. And China is confident that the international community will respect the facts and not to be misled by the lies. We call the state to check its own historical rights in relation to the crimes, to the atrocity crimes. In conclusion, Madam President, China expects the ICC to seriously take stock of achievements and lessons over the past 25 years, to respond positively to the concerns of all countries, to comply strictly with international law, to perform faithfully its duties with a view to contributing to the maintenance of sustainable peace and the realization of true justice through practical actions, and to win the firm trust and support of the international community. I thank you, Madam President.
I thank you for your statement. And now I give the floor to Ms. Abigail Frisch Ben Abraham, legal advisor of the Embassy of Israel to the Kingdom of the Netherlands.
Thank you, Madam President. Today marks 2 months since the horrific attacks perpetrated against Israel by Hamas and other terror organizations in the Gaza Strip. On Saturday, October 7th, Hamas launched a massive attack against Israel, during which thousands of terrorists infiltrated Israeli territory and in acts of ruthless and brutal savagery, murdered over 1,200 people from different religions, including Jews, Muslims, and Christians, and injured thousands more, while simultaneously firing thousands of rockets indiscriminately against Israeli civilian population centers. Israeli communities in the south of Israel were decimated. Entire families massacred in their homes, burned alive, and made to endure indescribable atrocities. Hundreds of young men and women celebrating in a music festival, viciously butchered. For weeks, many civilians remained unaccounted for. Some are still missing. It is precisely such atrocities that led to the creation of the International Criminal Justice Project, to which Israel has contributed and to which it remains committed. The horrific events of October 7th include widespread and often pre-planned gender-based violence, including rape and sexual assaults. 239 people were taken hostage by Hamas, among them babies, children, the disabled, and elderly people, and held incommunicado. At least 6 hostages have been executed by their captors. 138 people remain captive without any sign of life. This includes 10-month-old Kfir Bibas and his family. Those sadistic actions, which Hamas gleefully celebrates and openly and explicitly vows to commit again and again, are something no country will tolerate and every country will act against. Israel is duty-bound to protect its citizens and to ensure that the ongoing attacks and rocket fire can never occur again. Madam President, in responding to those atrocities, Israel is committed, as it must be, to upholding the laws of armed conflict, including the principles of distinction, precaution, and proportionality in accordance with international law. Israel remains committed even as it faces an enemy that has an utter contempt for the law and for human life, whether Israeli or Palestinian. Our heart goes out to the Palestinian civilians in Gaza who have been living under the brutal regime of Hamas for 16 long years. Israel is not fighting against the civilian population in Gaza. It is fighting Hamas. Hamas has spent the last 16 years smuggling arms and stealing aid intended to the civilian population of Gaza in order to transform that civilian infrastructure into one of the most entrenched terrorist strongholds in modern history. For Hamas, civilians are to be used as expandable human shields. It views mosques, schools, homes, UN facilities, and hospitals not as civilian objects deserving the protection, but as terrorists' launching pods. Its vast underground tunnel network, built from concrete meant for the civilian population, with hubs under hospitals and other civilian sites, is designed, as Hamas leaders have publicly acknowledged, to protect Hamas figures, not the civilian population. Madam President, any fair-minded observer must realize that the organizing challenge we face is the obligation to operate according to the law in the face of the abhorrent strategy of an enemy that disdains the law. As Israel is seeking to minimize civilian harm in accordance with the law, Hamas is seeking to maximize it. While for Israel every civilian casualty is a tragedy, for Hamas it is merely a pawn in its propaganda. Unless this horrible reality is appreciated, unless the brutal battlefield that Hamas has created is understood, no legal or factual analysis of the situation is serious. The outrage we have heard for civilian casualties must be directed first and foremost at those terrorist groups who continue to deliberately endanger both Israeli and Palestinian lives and to hold innocent people hostage. Madam President, we have heard the libels and charges made against Israel by some in this debate. Those outrageous claims are sadly not new, but neither are they connected to the facts or to the law. We heard the concern expressed for Palestinian civilian life. We share it. But we must ask, why did we not hear the voices of those speakers all those years when Hamas was brutally oppressing and targeting the civilians of Gaza, stealing aid and turning hospitals and schools into terrorist hubs? Why have we not heard nothing of the over 1,600 misfired terrorist rockets that have landed in Gaza itself, causing untold civilian harm? Why have they been unwilling, as the Palestinian Authority has been unwilling, to unequivocally condemn the Hamas and the terror attacks of October 7th? The answer is clear, and I suspect you all know it. It is because, as opposed to the Rome Statutes, that requires independent and impartial analysis based on accurate and well-founded understanding of the law and of the evidence, those speakers are acting out of a political, partisan agenda that has no place in the debate regarding a criminal judicial body. Genuine concerns for the law does not begin with addressing how Israel responds to the painful dilemmas Hamas exploitations of civilian poses. It begins by condemning Hamas and holding it accountable for creating that unforgivable dilemma in the first place. If you are unwilling to address that, if you cannot muster a response to the inhumanity and immortality of Hamas, you have told us all we need to know about your commitment to the law and to the facts. And you have signaled to all of us exactly how much weight should be attributed to your accusations. Politicization is a real obstacle to the integrity and effectiveness of the international criminal justice mechanism, and it must be addressed. When every action taken in war is immediately, deliberately, and automatically labeled as a war crime or crime against humanity, because it serves a convenient political narrative, we not only undermine the legal integrity of the international criminal justice project, we also dishonor the victims. If the ICC and the organs supporting it cannot be a place free from this kind of political manipulation and careless rhetoric, a place where the real facts matter, where the law as established matters, then it will betray its judicial function. Madam President, while Israel is not a party to the Rome Statute and has not changed its position regarding the court's jurisdiction, Israel takes note of the visit by the prosecutor last week, including his time in Israel at the invitation of families of victims and survivors of the October 7th attacks. Madam President, Israel's legal system is a testament to the commitment to the rule of law. It must, despite all the difficulties and tragic reality of urban warfare, respond with humanity to Hamas' inhumanity. Israel has initiated extensive law enforcement efforts against those who perpetrated, planned, and otherwise took part in the crimes of October 7th and subsequently. Israel is fully committed to this process and no resources will be spared. It will also work with other national jurisdictions to pursue this goal. Israel has in place independent and robust mechanisms, which include also civilian oversight and judicial review, for maintaining compliance with the law and examining allegations of violations and misconduct. As it has done previously, Israel's domestic legal system will examine and investigate any credible allegations of wrongdoing by its own forces. Israel is committed to upholding the rule of law. in all aspects, including against alleged extremist violence, and will treat it with all the severity of the law. Madam President, later today, the Jewish people will mark the first night of Hanukkah. Hanukkah is a testament to the Jewish people's deep connection to the land of Israel, as well as their ability to overcome anti-Semitism and hate, and to find hope and light even when all seems dark. Our prayers and thoughts remain with all of those that are still held hostage by Hamas. We call for their immediate and unconditional release. We will not give up on them. Neither we will give up on a future of peace, coexistence, and security for Israelis and Palestinians alike, free from the terrorism of Hamas and other terrorist organizations that endanger us both. Despite this dark time, light, justice, and hope shall once again prevail. Thank you, Madam President.
I thank you for your statement. And now I invite His Excellency, Mr. Yegishe Kirakosyan, representative of on international legal issues of Armenia.
Thank you. Ladies and gentlemen, I would like, first of all, to thank the President of the Assembly of State Parties, Her Excellency Silvia Fernandez de Gurmendi, for her leadership, and to wish distinguished Madam President much success in the future. And Armenia also congratulates the newly elected President of the Assembly, Her Excellency Päivi Kaukoranta, the member of the Bureau, and the candidates who have been elected as judges of the court. As an incoming member, Armenia would like to express appreciation for all welcoming messages that have been conveyed by the members of the Assembly throughout this debate. By acceding to the Rome Statute, Armenia will be the 124th member of the court, starting from the February of 2024, and the 19th member in the Eastern European group of the states. And Armenia has also made a declaration under Article 12.3 of recognizing the court jurisdiction retroactively starting from May the 10th of 2021. Armenia's decision to ratify the Rome Statute emphasizes our strong adherence to the values of international law and justice, and signifies our unequivocal commitment to upholding justice, fighting impunity, and ensuring accountability in the face of persistent challenges. As has been demonstrated so many times before, including in our own most recent history, and in our own very region, more often than not, it is the lack of accountability that breeds more violations and grave crimes. It is therefore an imperative that we collectively re-emphasize the importance of upholding the rule of law in times of conflict, specifically in times of conflict and crisis, because that's the problem for any country. And to punish or to prevent most egregious violations of heinous crimes that shake the very foundations of international law and humanity. Historically, including the very recent history, having experienced devastating consequences of violence and conflicts, Armenia very well understands the grave impact that those conflicts and crimes have on communities and societies. By becoming a state party to the Rome Statute, we express our commitment to effective international action to ensure that accountability for the gravest crimes is not only sought but also achieved, that victims receive justice and redress, and that the perpetrators are held accountable. And I think we as a country consider that this can be only achieved through this striving through universalization, or the aiming at universalization of the court. Armenia has already started taking up necessary steps internally to conduct necessary steps to implement the commitments that are stemming out of the Rome Statute, including the legislative and other necessary steps that will be deemed necessary to ensure the swift implementation of all the commitments assumed under the treaty. And as ever, Armenia remains strongly committed to the effective prevention and punishment of acts of genocide, war crimes, crimes against humanity, and addressing and combating impunity for such crimes is an essential duty of every member state. And I would like to conclude by reiterating Armenia's steadfast determination to support efforts to effectively address and prevent new and recurring atrocities and to ensure tangible progress in this regard. Thank you for your attention.
I thank you for your statement. And now we will proceed with statements by international organizations and other entities. And our first speaker is Mr. And the next speaker is Mr. Sunil Pal from the International Development Law Organization.
Thank you, Madam President. Excellencies, distinguished colleagues, it's my honor to deliver this statement on behalf of the International Development Law Organization, the only global intergovernmental organization exclusively devoted to promoting the rule of law and access to justice to advance peace and sustainable development. We gather at a time when trust is in short supply, both across and within states. This lack of trust permeates in national and global governance structures. Moreover, conflict-related deaths and international law violations have dramatically increased in the last few years. We cannot talk, though, of justice without acknowledging the plight of those that justice is intended to serve. We have one message in this respect. It is that in these times, universal adherence to the rule of law and justice and accountability are paramount. In its 40 years of operating across the globe, IDLO has sought to foster a culture of justice at the national and local levels by strengthening access to people-centered justice, whether through formal courts of law or customary and informal justice mechanisms. We welcome, therefore, the role that states, as well as civil society actors, have and should continue to play in ensuring accountability for atrocity crimes and supporting victims and affected communities. The rule of law and justice, however, must be pursued consistently and with the same vigor in all situations, regardless of where such atrocities occur. This is key to ensuring that justice and accountability are truly equitable and universal, and key to rebuilding trust. For its part, IDLO has supported state efforts in strengthening rule of law and justice sectors, including those that seek justice through international mechanisms, as is the case with our support to the Office of the Prosecutor General in Ukraine. Excellencies, these times are a tough test for the rule of law and for justice and human rights across the globe. Multiple crises have put peace and sustainable development at risk. And as we celebrate the 75th anniversary of the Universal Declaration of Human Rights, the 25th anniversary of the Rome Statute, as well as the 40th anniversary of IDLO, we dedicate ourselves to working with all partners to champion the rule of law as a catalyst for transformative change. Madam President, I have just about 3 minutes left of my time, but I give them back to you. Thank you very much.
I thank you very much, including thank you for the 3 minutes. And now I invite the President of the International Criminal Court Bar Association, Ms. Marie-Hélène Proulx, to deliver her statement.
Madame la Présidente de l'Assemblée des États parties, Excellences.
President, members of states parties, representatives of international non-governmental organizations, I am honored to address you once again this year in my capacity as chair of the ICC Bar Association on behalf of the external counsel representing the defense and victims before the court. I would above all like to highlight what we have done since our last assembly. At this time last year, the support staff for the council were on strike in order to uphold their right to minimal working conditions. And you heard them and you gave them historic interim measures. Today, the legal aid reform that was long expected is finally within reach, and together with it, finally is guaranteed the basic labour rights. Significant improvements have also been made to the composition of teams, whereas new measures allowing us to increase the geographical representation of teams is also on its way, and for this we are grateful.
We remain concerned by the number of unresolved issues pertaining to the implementation of the new legal aid policy, as well as by the persistent lack of recognition of the crucial role played by external counsel in ICC proceedings. Notably, the ICCBA is very worried by the unexplained last-minute deletion in the legal aid policy of the undisputable principle of equality, emphasizing that the work of external counsel is of equal importance and requires commensurate skill, professionalism, and responsibility in advancing fair proceedings akin to their counterparts of the court, and that as such, their remuneration should be comparable. Maintaining equivalency is not only vital to retaining competent counsel who are willing to take on demanding and lengthy ICC cases, but it is also an essential condition of the fundamental right to equality of arms and fair trial. When the ASP adopted the previous legal aid policy at its 11th session, it recognized in plain terms, and I quote, "the fundamental importance of the legal aid system to ensure the fairness of the proceedings and the right of the defendants and victims to quality and professional legal representation." This must remain a core principle of the policy under consideration, even now. 10 years on, I urge you to reaffirm your commitment to these principles in the legal aid policy to be adopted next week by reinstating the equivalency of external counsel with their counterparts of the court. Counsel for the defense and legal representatives of victims are not just empty robes. They are essential partners in the international justice system and must be valued as such. In 2024, the ICCBA will continue to vigorously advocate for improved conditions for external counsel, including by requesting adjustments to the remuneration scheme to better reflect the importance of their contribution to the justice process and to take into account the increased cost of living in the host state. Under the new legal aid policy, counsel will still be paid over 40% less than their counterparts of the court, meaning that they are in fact working for free at least 4 months out of 12. This grave disparity is affecting the retention of staff in existing teams and hindering the recruitment of new and experienced counsel going forward. For the court to uphold its ambition to remain a beacon of global justice, it must address the chronic underfunding of the legal aid. Failure to do so jeopardizes fulfilling its mandate to provide fair trial to suspects and accused and meaningful participation of victims as enshrined in the Rome Statute. This assembly holds the authority to actualize the promises of the Rome Statute by respecting external counsel for defense and victims as integral partners of the justice process. The support of the Assembly on this important issue would be appreciated, as ultimately the court will not provide justice outwardly if we are not just inwardly. Thank you.
I thank you for your statement, and now I give the floor I give the floor to non-governmental organizations The Bureau also recommended that 45 minutes be allocated to them. And now I invite Mr. Ali Omar from the Libyan Crimes Watch on behalf of a coalition of Libyan civil society organizations.
Thank you.
Ladies and gentlemen, excellencies, it is an honor to deliver this statement on behalf of Libyan Crimes Watch and Lawyers for Justice in Libya, as well as partner organizations working on the Libyan file and in Libya. We wish to express our deep disappointment amidst the lack of any tangible progress in ongoing investigations in Libya since the beginning of the work of the ICC therein in 2011. In his briefing to the Security Council last November, the prosecutor announced his office's resolve to complete investigations by 2025 without clarifying the standards and requirements that will have to be fulfilled before the investigations are completed. He has also not consulted civil society organizations nor victims and affected communities before delivering that briefing. This announcement took the civil society and victims in Libya aback, especially 12 years into the referral of the Libyan dossier to the ICC. The accountability of perpetrators and justice for victims of war crimes and crimes against humanity perpetrated in Libya have yet to be achieved. We also wish to point out the lack of effective communication between the prosecutor's office and victims and CSOs working in the field in Libya to document crimes and collect evidence. They have been subjected to constant repression and reprisals due to the nature of their work. And as mentioned by the prosecutor, the Libyan authorities have not cooperated with the ICC. They have hindered the issuance of necessary authorizations for the office of the prosecutor to be able to conduct necessary investigations in Libya. And this has curtailed investigations in the field and led to lack of access to necessary witnesses and evidence. The Libyan judiciary is incapable and unwilling to conduct necessary independent investigations and hold perpetrators of serious international crimes perpetrated against Libyans and residents in Libya. In addition, magistrates and lawyers in Libya have been subjected to arbitrary detention and threats by state-affiliated armed groups, as mentioned in the outcome report of the UN fact-finding mission on Libya. The completion of investigations without making tangible progress and accountability of perpetrators fans the flames of impunity and encourages perpetrators to continue on perpetrating their crimes. It also undermines victims' hope for justice. Therefore, we call upon the prosecutor to reconsider his announcement on the completion of investigations by 2025. We call upon him to expedite efforts to issue necessary arrest warrants against perpetrators of war crimes and crimes against humanity in Libya. We call upon member states, including Libyan authorities, to ensure a safe environment for civil society organizations and human rights defenders. They constitute the core link between the ICC and witnesses and victims, and they are to be protected from oppression at all costs. In closing, we call upon member states to provide all necessary resources to the court, including necessary financial support to allow for the sustainment of investigations in Libya, and we call upon them to cooperate with the ICC to enforce arrest warrants. In closing, the only hope of the victims is the ICC. It is the only mechanism to allow for accountability of perpetrators and the achievement of justice. Thank you for your kind attention.
I thank you for your statement. And I thank you for your statement, and now I invite Ms. Priya Pillai from the Asia Justice Coalition.
Your Excellencies, dear colleagues, it is an honor to address this Assembly of States Parties to the International Criminal Court with our fellow civil society organizations. The purpose of the Asia Justice Coalition is to promote justice and accountability for gross violations of international human rights law and serious violations of international humanitarian law in Asia. We believe that justice, holistic justice, is the only antidote to impunity, and that accountability for international crimes, domestic, regional, and international, is a significant part of this holistic justice. Amongst its many traits, holistic justice is inclusive. In this vein, and in line with our work to bolster women's leadership in international justice in our region, we welcome the Court's commitment to gender equality. This is reflected in its strategy on gender equality and workplace culture and the newly launched policy on gender-based crimes, which we commend. To fully address the gendered blind spots still present across practice, we call for the continued understanding of the value and agency of women in utilizing and progressing international law. Holistic justice is also timely. As an Asian-based, Asia-focused coalition whose founding focus was accountability for the crimes against the Rohingya people of Myanmar, we are acutely aware that the International Criminal Court remains the only forum investigating deportation and persecution to address individual criminal responsibility. The prosecutorial and judicial creativity facilitating the jurisdiction of the court in the Bangladesh-Myanmar situation is much appreciated. That said, we gather at a time when the situation in Myanmar has only continued to worsen. Since the 2021 coup, Myanmar's military has continued to commit crimes against humanity and war crimes in a brazen display of impunity. This is while the victims and survivors of Myanmar military's clearance operations, the Rohingya, continue to await visible progress and next steps in the situation. Therefore, we call for a consistent and speedier discharge of the court's mandate, including moving the Bangladesh-Myanmar investigation forward. Finally, holistic justice is collaborative. We emphasize the absolutely invaluable role that civil society plays in addressing impunity for international crimes. We call on the court to continue to strengthen its commitment to meaningful engagement and transparent communication with civil society, and we call on states parties to strengthen support for witnesses and those that engage with the court. In the spirit of inclusive, timely, and collaborative justice, holistic justice, that brings us to this work, I thank you.
I thank you. And now I give the floor to Mr. Emmanuel Manwangari from the Burundi National Coalition for the ICC.
Vos Excellences,
Excellencies, ladies and gentlemen, it is a privilege and a great honor to be able to take this opportunity and to have this time before this august assembly in order to talk to you about the human rights situation since the opening of the investigation. This was followed by the withdrawal of Burundi, my country, from the Rome Statute and from the ICC in October of 2017. And thus, the day after this withdrawal became effective, Burundi refused to collaborate with the court, and the investigators were not able to access the territory in order to carry out their investigation in conformity with the ruling of the preliminary chamber number 3 of the ICC on the 25th of October 2017. Currently, victims are still living in fear and suffering from the trauma of what happened. Above all, they fear for the torturers who are still in freedom. Despite the change of regime that took place in Burundi in 2020, the human rights situation in the country remains worrying. Of course, we welcome the good words of the President, but this is not enough for the Burundian people. They need concrete actions and, above all, an end to the violations of human rights, and they need the prosecution of the perpetrators of grave crimes that continue to be committed in impunity. Withdrawal from the Rome Statute and preventing victims from accessing restorative justice is a suffering that has been imposed on Burundians in general and to the families of the victims in particular. As a result, the Burundian Coalition for the ICC continues to call on Burundi to do the following. Firstly, to authorize entry onto the territory of the investigators of the Office of the Prosecutor of the ICC, and to furthermore allow the victims or their families who are still in Burundi to have an exchange with the investigators without fear of reprisals. The perpetrators and their accomplices and anyone who participated in them should be brought to justice if they are circulating freely, and above all if they are occupying strategic posts within Burundian institutions. We must show the jurisdiction of the ICC and reassure victims. We should also provide financial support to the investigators and the Office of the Prosecutor in order to close the investigations, and psychosocial support and protection is necessary for the victims who are in starting to despair 6 years after the investigation. I thank you.
I thank you for your statement, and now I invite Mr. Ahmed Abouful on behalf of Al-Haq, Al-Mason Center for Human Rights, the Palestinian Center for Human Rights, Defense for Children Palestine, and the International Federation for Human Rights.
Thank you, Madam President. Excellencies, thank you for the opportunity to address you today, which comes at a time of a dire moment, as Israeli officials and armed forces brazenly demonstrate a near complete disregard of international law. Through the overt acts alleged to amount to war crimes, crimes against humanity, and genocide. For decades, Palestinian human rights organizations have consistently documented and exposed alleged atrocity crimes perpetrated by Israeli forces against the Palestinians living in the occupied West Bank, including East Jerusalem and the Gaza Strip. Our organizations have routinely documented unceasing Israeli war crimes and crimes against humanity, including the crime of apartheid and persecution perpetrated against the Palestinian people as a whole. Excellencies, these international crimes by Israeli authorities and military have been and continue to be pursued as part of Israel's 56-year illegal belligerent occupation of the Palestinian territory, the longest occupation in modern history, and its 16-year-long suffocating, medieval-like closure and blockade of the Gaza Strip, a measure of collective punishment and persecution of over 2.3 million people. Furthermore, it must be said that the backdrop of these flagrant violations of international law and the genocide unfolding and we're witnessing today is Israel's 75-year settler colonial apartheid regime that has been denying the Palestinian people their inalienable rights, including the rights of determination and return. Our efforts to seek justice and accountability on behalf of Palestinian victims have been constant. Yet, despite the overwhelming evidence, the international community has failed to hold Israeli officials and military personnel accountable, and has instead worked to directly and indirectly perpetuate impunity for international crimes and gross human rights violations. Now, the world is witnessing the result of systematic impunity, that is, the unfolding genocide of the Palestinian people. Over the past 2 months, Israeli attacks in Gaza killed over 16,000 Palestinians, including over 7,000 children, with thousands of others under the rubble, most likely dead. Almost 1.9 million Palestinians in Gaza, nearly 85% of the population, are internally displaced. Unprecedented killing and displacement are compounded by the decision of Israel's defense minister to implement a total siege, cutting out electricity, fuel, food, water, and humanitarian supplies. In their totality, these actions by Israeli authorities and the military can only be characterized as creating conditions of life to bring about the physical destruction of the Palestinian people in Gaza. Last month, the United Nations observed a minute of silence to honor the more than 100 UN employees killed in Gaza in Israeli attacks, the largest toll of humanitarian workers in the organization's history. Just yesterday, the Secretary General urged the Security Council to act on the crisis in Gaza as a threat to international peace and security, noting that nowhere in Gaza is safe, and there is a severe risk that the humanitarian system will collapse due to the intensity of Israeli bombardment. Excellencies, state parties must ensure that the court has the resources it needs within its regular budget and the requisite level of cooperation needed to deliver on its mandate. We also commend state parties that mentioned Palestine in their statements and unequivocally called for accountability for victims of atrocity crimes. However, we regret the statements of states that acted like Palestinian victims are invisible, while enthusiastically calling for accountability in other situations. Double standards, hypocrisy, and selectivity should have no place at this assembly, nor international justice in general. Excellencies, we welcome the prosecutor's office visit to Rafah and his recent statement reiterating that willfully impeding relief supplies to civilians may constitute a war crime under the Rome Statute. However, since his visit on 29th of October, the Palestinian death toll has more than doubled, and Israeli forces having destroyed the northern of the Gaza Strip, are now intensively targeting areas in the south. Through their statements and actions, Israeli authorities and military are shouting to the world that they will not be deterred from their campaign of genocide against the Palestinians in Gaza. Warnings are not enough in the face of an unfolding genocide of the Palestinian people. Action on all levels is needed now. We urge the Office of the Prosecutor to imminently issue arrest warrants and expedite the investigation into war crimes related to Israeli illegal colonial settlements in the occupied West Bank, including East Jerusalem, crimes against humanity, including apartheid and persecution, and to investigate and prosecute Israeli officials and military personnel responsible for the commission of international crimes that have been orchestrated across the occupied Palestinian territory, including East Jerusalem, as a matter of priority, especially crimes committed against and affecting children. Excellencies, the Office of the Prosecutor must deliver on its mandate without fear or favor. It must act now, because the cost of every minute delay is more Palestinian civilians, including children, killed. Never again is now. Thank you.
Thank you. And now I give the floor to the representative of Venezuelan civil society on behalf of Platform Justicia y Verdad.
Thank you, Madam President. This statement is a joint statement by various organizations of Venezuelan civil society committed to achieving truth and authentic justice for the crimes against humanity that have been committed and continue to be committed in our country. The investigation of Venezuela 1 that is currently awaiting sentencing in room 1 of the court has become the only hope for victims to achieve genuine justice. The unprecedented participation of 8,900 victims as 630 families that requested the resumption of investigation is a eloquent testimony of their will and commitment. This same situation and requests demonstrate that the prosecutors and the Office of Defense of Victims, what they argued in latest hearings, is also historic, that there is no reason to think that in Venezuela investigations are being carried out that are complying with the standards of the Rome Statute. This is why once the decision of the appeals room is known, procedures will start to establish individual responsibilities. It's important to highlight that all these facts continue to occur in our country. As indicated in the last report of the independent mission for the determination of facts, the repressive system in our country is intact. Our duty is to continue to reveal the nature and the evolution of the system by comparing it with the misleading narrative of normalization that the Venezuelan government is trying to promote. It's important to have independent and impartial national processes, but separately from the investigation conducted by the prosecutor. National authorities should not try to avoid this, to delay the current processes before the International Criminal Court. Civil society should be allowed to participate in additional activities that are being conducted in Venezuela. It's important to counter the biased information provided by the government, and also we hope that it's important that the representatives of civil society that speak out are protected. It's also important that the prosecutor's office of the ICC publicize information about an agreement signed with the organizations of civil society. Madam President, in conclusion, we'd like to say that we're united by an unbreakable conviction that justice and reparation is essential for those who've suffered the consequences of crimes. It's not only important for the past, but also for the future of all our nations. We are grateful for the support of this assembly and for the court, and in helping Venezuelans to achieve justice. Thank you very much. Thank you.
Muchas gracias por su. Muchas gracias.
Thank you for this statement.
Ms. Melinda Reed from the Coalition for the International Criminal Court.
Excellencies, ladies and gentlemen, it is with honor that I address you today as the Director of the Secretariat for the Coalition for the ICC. The Coalition is the world's largest civil society partnership. We are represented at this ASP session by more than 200 individual human rights defenders from all around the world. Some of our colleagues face threats and reprisals against themselves, their families, and their colleagues because of the work they do to speak out against injustice. Those who cooperate with the court face immense challenges in their fight to bring justice to victims and for their work in support of the Rome Statute system. We call on states parties and the ASP as a whole to protect and defend civil society and human rights defenders who are at risk because of their engagement. In the face of threats and sanctions against the court and its officials, your collective diplomatic and practical support for the court is also critical. We call on your governments to defend, protect, and cooperate with the court and to uphold the integrity of the Rome Statute. In these dire times, the principles and commitments of the Rome Statute are more crucial than ever. This ASP session should serve as a key forum for your governments to demonstrate to victims around the world your resolve to reinforce the role of the ICC in the wider international justice system and enforce the principle of complementarity. We hear the ICC principles stating that they need more support to be able to fully and effectively implement their mandate. We hear our colleagues in situation countries and other regions telling us that the court's presence is not felt, that the court is not understood, that victims have not seen justice or heard from the court in many years, that victims have not received reparations. The lack of sufficient resources for the entire court risks having a profound impact on victims' access to justice and becoming a severe impediment to the optimal functioning of the court. Despite all the challenges, many around the world are still looking at the Rome Statute system with hope. Notably, Armenia has just become the 124th state party to the Rome Statute, an important step to reduce the impunity gap and encouragement to other states to join this global effort. Congratulations and welcome to Armenia. Excellencies, ladies and gentlemen, this Assembly has just elected 6 new judges on the ICC's bench. Congratulations. These judges arrive at a crucial time in the history of the court, facing an unprecedented level of activity. We call on states to adopt the draft due diligence procedure or vetting for elected officials. We would also like to congratulate the new ASP presidency and bureau and bid farewell and thank you to outgoing members at the end of the session. We value our unique consultative status with the court and the ASP, and we urge the Assembly to maintain and strengthen access to ASP processes for civil society. 2023 has been a critical year for international justice. Today, the ICC often remains a last beacon of hope for victims who have no other avenue for justice. The success of the court and the Rome Statute system cannot depend on the institution alone. It depends on you, its states parties, and on the decisions you will take in the next days. Thank you.
I thank you. I thank you. And now I invite Ms. Aurora Parong on behalf of Philippines Coalition for the ICC, Amnesty International Philippines, and Children's Legal Rights and Development Center.
Madam President, Excellencies, ladies and gentlemen, thank you for this opportunity to speak. I come from a small country so far away from the International Criminal Court in The Hague and the United Nations here in New York. One city mayor who became president in our country thinks that some people have to be killed. This resulted to massive atrocities. The Philippine situation is now under investigation by the ICC for crimes against humanity in the context of the war on drugs. About 30,000 people, including children, were killed in police and other operations which are deemed led or instigated by law enforcement agents and high officials. To date, the killings continue despite the change in government. The Philippines withdrew from the Rome Statute in 2019 after a preliminary examination was started. The Philippines has also publicly attacked officials of the ICC and vowed non-cooperation with the court, while there is no credible investigation of high government officials who made the massive killings possible and no prosecution of serious international crimes. Very few government officials support cooperation with the ICC. The new government is still studying possible cooperation with the court. Madam President, Excellencies, there is impunity for serious international crimes in the Philippines. Only 4 policemen have been convicted for the killing of 3 teenagers, despite the tens of thousands killed. The families of victims of killings by the Davao death squads, as well as those killed in the nationwide rampage against rights and the rule of law under the previous government, the families are grieving and suffering. The emotional turmoil is aggravated by the stagnation of domestic criminal investigations and prosecution on killings in a bloody war on drugs. The victims continue to wait for the wheels of justice to tilt in their favor, pinning high hopes on the ICC as a court of last resort to deliver justice, which is so elusive in our part of the world. The victims and their families continue to hold on to that small light of hope that elusive justice will be found at the International Criminal Court. We note that so many victims around the world are hoping for justice through the ICC. We note with concern that the ICC has been underfunded with a very significant and long-standing gap between the court's workload and the resources available in its regular budget. We are anxious that there may be hibernation or delays in court processes due to inadequate resources, and we fear that we in the Philippines may have that problem of being hibernated. Madam President, Excellencies, we highly welcome the support of the ASP for the ICC as a court of last resort, but this must be matched with corresponding resources. No stone should be left unturned to deliver justice, which help deter future atrocities. Legal aid, assistance, reparations for victims must be efficient and sustainable to help them pursue the enjoyment of their basic rights. We appeal to the Assembly of State Parties to provide the political support as well as adequate resources that the International Criminal Court needs in order to efficiently and effectively deliver justice without fear or favor. Justice is a birthright for everyone. No one should be left behind. Thank you very much.
I thank you. At this stage, I would like to thank interpreters for having extended their interpretation services until now. And but we still have three more speakers, and that would be the end of the list. So if you agree to proceed without interpretation to complete the list for these three last speakers, I understand the speakers also agree. But I would like to know if that would be agreeable to you all. I see no objection, so we will continue. I thank again the interpreters for their assistance today. And now I'll give the floor to Ms. Cobra Moradi from the Afghanistan Human Rights and Democracy Organization.
Thank you, Madam President, distinguished delegates, ladies and gentlemen. Thank you for giving me the opportunity to address this assembly today on behalf of the Afghanistan Human Rights and Democracy Organization, the Afghanistan Transitional Justice Coordination Group, the International Center for Transitional Justice, and the Coalition for the Prevention of Hazara Genocide. Madam President, the people of Afghanistan have suffered unimaginable suffering and loss. Our quest for justice and accountability is an urgent plea that echoes the sentiments of a people scarred by cycles of violence, criminality, and impunity. Afghans are currently facing one of the worst human rights crises in the world. Vulnerable victims, including women and girls, ethnic and religious minorities, such as the Hazara people, the LGBTQ community, members of the former government, and human rights defenders are subjected to violent attacks. Today, it has become a curse to be born a female in Afghanistan. The Taliban's all-male gender apartheid regime has passed a litany of edicts that deprive Afghan women and girls of their most basic rights and freedoms, aimed at controlling every aspect of their lives and excluding them from public life and society. The situation in Afghanistan calls for urgent, decisive, and coordinated action by the international community, and that includes the International Criminal Court. Thousands of Avon victims have been waiting for decades for justice, for the realization of what has been described by the ICC prosecutor as a birthright. My aunt, whose husband was forcibly disappeared, never recovered from the shock and loss. She waited all her life for justice, for his possible return. He never returned, and she passed away, never seeing justice, truth, and never experiencing healing. In the absence of accountability mechanisms in Afghanistan under the Taliban regime, the International Criminal Court remains one of the primary avenues for delivering justice to Afghan victims. Afghan victims deserve justice and an end to impunity, and we therefore call on the International Criminal Court to ensure that its investigations addresses all crimes by all parties to the conflict, including the Taliban, the ISKP, and national and international forces. We urge the Office of the Prosecutor to avoid delays in its investigations and ensure timely access to justice to Afghan victims. We further urge members of this Assembly to support accountability efforts for Afghan victims by supporting the International Criminal Court's investigations. We urge members of this Assembly to support the inclusion of gender apartheid as a crime in the draft articles on crimes against humanity in order to allow responding to the gender apartheid in Afghanistan and beyond. We urge member states, in particular those involved militarily in Afghanistan, to ensure transparent and meaningful investigations into alleged war crimes committed by their own forces in Afghanistan in accordance with the principle of complementarity. It's time to end impunity for atrocity crimes and to deliver justice to Afghan victims. Thank you for your attention.
I thank you for your statement. And now I give the floor to Ms. Nadia Volkova on behalf of Ukraine 5 a.m. Coalition and Global Initiative Tribunal for Putin.
Thank you, Madam President. Excellencies, distinguished delegates, dear colleagues and friends. I am honored to address you today on behalf of Ukraine 5 a.m. Coalition and Ukraine's Global Initiative Tribunal for Putin. Last year, when I was addressing you 9 months into the invasion of Ukraine, I urged you to demonstrate that justice response from your states, which was perceived by many as effective justice and as the one to look up to in other situation countries, was not just a mirage, but something that had a real effect on the lives of those who suffered from the most heinous crimes for 10 years of the ongoing armed conflict in the territory of Ukraine. A year in, I would like to invite you to take stock of what has and has not been achieved to make justice a reality for the victims of the Russian war against Ukraine. The International Criminal Court has issued 2 arrest warrants against the Russian president and Child's commissioner. The OTP are investigating the deportation case in Ukraine, and the field office was opened to support its operations on the ground. Ukraine, despite many years of civil society's campaigning, populations and some of the government's institutions' support of the ratification, numerous calls to ratify the Rome Statute by the states and the EU, is still not a state party to the Rome Statute. Court's budget is still not sufficient to support registry's activities such as outreach in Ukraine field office. In practical terms, lack of Ukraine's ratification and lack of outreach means that the OTP will not be able to conduct as effective, independent, and impartial investigation as it potentially could, due to selective cooperation on the part of the state authorities and missed opportunities to engage with victims and witnesses. To this end, we urge you, Excellencies, firstly, to be more persistent in your efforts to convince the responsible Ukrainian counterparts to ratify the Rome Statute without any further delay. Secondly, to increase the court's regular budget across all organs so that there is enough financial capacity to sustain their operations in field offices as well as HQ. In relation to complementarity, prosecutor of the ICC declared many times over the past months that effective implementation of the principle of complementarity was a priority for his office. Ukrainian authorities have opened over 110,000 investigations since the beginning of the full-scale invasion, excluding all the investigations from pre-invasion period that are still pending. Much of the international support has been invested into developing the capacity of domestic authorities to effectively investigate and prosecute core crimes. New and existing regional mechanisms have been created and engaged. Yet, many existing obstacles, such as the scale of the violations, lack of suitable legislative framework, lack of resources across all affected regions, lack of effective coordination among authorities, and ongoing armed hostilities, to name a few, render these efforts insufficient. Victims have more trust towards international institutions according to the polls and feedback we receive from them. To this end, we urge you to consider solutions which would ensure meaningful implementation of the principle of complementarity based on the robust and critical assessment of the domestic justice system of Ukraine and its capacity to ensure accountability for all 4 crimes for the sake of achieving real and not perfunctory justice for the victims of this war. Only real justice can provide hope for humanity. Thank you.
I thank you, and now I give the floor to Ms. Elizabeth Evenson of Human Rights Watch.
Madam President and Excellencies, thank you for staying until the end to listen to our NGO voices. 25 years on from the Rome Conference, the mandate of the International Criminal Court is regrettably all too relevant. The ICC is needed to act as armed conflicts and other human rights and humanitarian crises rage in situations across its docket, whether in Afghanistan, Darfur, the Democratic Republic of Congo, Palestine, or Ukraine. Any hope of deterring future atrocities rests in ensuring there are consequences for the crimes of today, regardless of where they are committed and by whom. To succeed in its difficult but vital task, the ICC needs you, its states parties, to do more. First, the Assembly of States Parties should commit to challenging double standards in the reach of justice. Ignoring or marginalizing the ICC's critical role in the context of ongoing hostilities between Israel and Palestinian armed groups, or indeed in any situation where the ICC is acting while selectively supporting other situations, will only confirm for many that the court does not have the support of its states parties to pursue justice impartially. We look to you to address double standards by pledging support to all situations under the court's jurisdiction and by advocating for universal ratification of the Rome Statute. Second, in practice, ensuring the court's consistent implementation of its mandate requires you to adopt a budget that allows the court's organs to exercise their functions across all situations. A lack of resources should not be an excuse for inequality in victims' access to justice. Third, the ICC will inevitably face efforts to thwart accountability. Justice needs your support to overcome these threats and reprisals, including against those cooperating with the court. We welcome the Assembly's commitment to protecting civic space during its sessions and look to you to take further steps next year. Fourth, the adoption of a permanent vetting process and a structured, ongoing follow-up to the independent expert review by this Assembly will contribute to improving the court's performance. This, as much as anything, is needed to deliver on the promises of Rome. This Assembly and the court it serves inspire us precisely because the Rome Statute system seeks to ensure that no one is above the law and no victim so unimportant as to be ignored by the law. Your actions at this assembly and beyond are needed to carry human rights protections forward in these fragile and dangerous times and to achieve peace, security, and well-being of the world. Thank you.
I thank you for your statement, and I thank you all for having observed the time limit. So that has allowed us to complete the general debate today. I thank you also for staying a little bit further beyond 6 and without interpretation the last segment. So I thank you all speakers for your statements presented during this general debate agenda and for the support that you had pledged to the court. So this meeting is adjourned.